right, good evening, everybody, and thank you for letting us appear with you tonight. It's almost like we're in a room together, so we're excited to do this. My name is Eric Boughman, and I'm joined on the screen there to my left is my partner, Gary Forster.
Hello.
And tonight we will be talking about the latest trends in asset protection, and we're going to cover some basics in domestic asset protection. And with that, we hope to provide you actually with some takeaways that will be helpful in your practice, and so you'll have a better understanding of some mechanisms that are, some easy and some more complex to aid your clients. And so you have a better understanding yourselves. And then we're going to dig into, do a little bit of background on cryptocurrencies and use that as a segue into foreign trusts. And maybe a few months back, I had written something for Forbes, and Gary and I have presented this a couple times now, this cryptocurrency and foreign trust asset protection process, and it's been pretty popular. So we hope that you'll get something out of that. And like I said, if you have questions along the way, please fire away at us. So I am working on a new computer tonight, and okay, there we go. So I'll try and keep us on track. So this is our agenda of how we're going to approach everything. And as Andrew said, we anticipate a break about halfway through. So probably before we dig into the cryptocurrencies, we'll probably be around the break point. Again, any questions, you can address them now, or we encourage you to shoot email if you think of something afterwards. You can always call us or send us a message, and we will try to address the question. Tonight we're gonna talk about first the basics of asset protection. We'll talk about entities, mostly LLCs. We'll talk about domestic trusts, and when we say domestic asset protection trust, that's a self-settled trust, where the grantor, I set up a trust for myself, and that's available in certain jurisdictions. We'll talk about how creditors use different legal theories to try and access protected assets. And off of that, we'll talk about some keys to effectiveness for asset protection. And what we draw on for that is typically is legal interpretations that are developed through the cases. So there's a lot of theory, there's a lot of law that we'll talk about. But anybody that's had experience in this area, or even for instance, when you deal with the IRS, sometimes you don't know what the interpretation of some law is going to be until it's actually challenged in court. And from those court opinions, that's where we really develop the nuances of the practice. And then, as I said, cryptocurrencies, we'll talk about foreign trusts. Gary's going to take you deep into the tax of foreign trusts. It gets a little complicated, but he's got a great outline, and he knows this as well as anybody, really probably as well as anybody in the country. He's written on the topic, and hopefully you'll find a lot of value in that.
And there are, I don't know if Andrew got the books, but there are a few books there on foreign tax and asset protection. We also had forwarded several of our compilation. It's called the FBL report, which has a lot of background asset protection articles. We're a last minute stand-in, so we want to make sure, we're a boutique law firm in the Orlando area, and we do basically corporate tax and international work, and we've just developed this specialty in asset protection, which we've been doing for about 12 years now. So if we're on a topic and it just triggers a question related or unrelated, please just ask. These seminars tend to go much better when we get some participation, and we know this stuff comes up day to day. We do a lot of international work out of South Florida as well. If you have a question on that, just feel free to tell Andrew, and he can either let us know, or he can type it into the there's a type-in thing for the constant contact.
All right, and so as we get to the end, we'll try and tie everything back together, and again leave some time at the end for discussion as well. So coming into an introduction and overview discussion of asset protection, what we're trying to accomplish is to use existing laws which include protective statutes, exemptions, things like Florida homestead, wage exemptions, retirement accounts, protective structures like LLCs, trusts. Use all available mechanisms that the law provides to insulate businesses and business owners from legal risk. Oftentimes people equate asset protection with hiding assets or evading the IRS or dodging your creditors and obligations, and that's not what is intended. In fact, a simple way to kind of to boil down when you're dealing with asset protection and when you're dealing with just hiding and evading is whether you're planning in advance or you are reacting. And if you are looking at your situation saying, well, I want to save some for a rainy day, you have the option. If you have assets, you could gift those assets to somebody. You could go on a spending spree and take trips and spend lots of money, or you could put some away. And the theory with asset protection is you shouldn't be penalized because you're frugal with your money and you decide to save for a rainy day, whether that's putting stuff away for family and for others that you care for, or putting it away for yourself. As long as you do that in advance of any cloudy time, so to speak, when the skies are clear, then asset protection is perfectly legal and something that anybody in that situation should certainly consider.
Eric, you're still on the title slide. Can you go through the slides, because you haven't changed slides?
Yeah, we have.
Okay, I have on my end. So let's see. Is it flipping over?
You should have just been using the arrows, or did you touch something else?
No, I'm just using the arrows. I used the pad so let's see. Is anything changing?
No, in fact, what happened was the slide got smaller. So why don't you unshare and reshare again?
Okay.
So go to the top there where it says sharing. Stop sharing and reshare.
Interesting. Okay.
Reshare.
Reshare.
That's a technical term.
Stop sharing and share.
Stop showing screen. Okay.
Now you're still showing the screen.
I hit stop showing screen and it's
Well, they're fixing
all right.
that. Everybody has handouts too that has all the slides and places you can take notes.
Look at the hand. They got the handout.
If not, I'll take over. So give yourself another minute.
I don't know why I'm flipping through and this is quite odd.
That was it. That's what you.
Give it a second. If not, I'll take it.
What's it look like now? Because what it says.
Yeah, now we're on the agenda slide. There we go.
Okay.
So go one more slide just to make sure that it's working. Okay, good. Okay, go back and take it from there.
All right, so this is the slide that we should have been on. My apologies for that. So we just talked about an overview of asset protection and what the goal is and address some misconceptions.
And so the idea of asset protection, is obviously if you get into litigation or a claim against you that what you have is not available, it's really a question of becoming unattractive. So if you have clients with substantial assets, what happens when they get into litigation typically is that there's a number of defendants involved. And what you want is for your client to be unattractive. The other investor that they have in the partnership may have nothing, so all of the attention shifts to your client with the assets, and we want your client with the assets to be as unattractive as the guy with nothing.
That's right, and we use it as a litigation bargaining chip as well. So I do a lot of business litigation, and I've been in situations where clients are sued or threatened with a lawsuit. And the way we approach it is I've been in situations where I'll take a well-formed structure. So Gary may have done an asset protection or some type of corporate structure that incorporates business planning with parent and subsidiary companies and a holding company, and then also individual planning. And I take that structure and I share it with my opposition. There's no hiding anything. We're an open book, and I say, okay, this is what you're dealing with. This is why my client isn't as attractive a prospect for suit as you think. When you realize that his ownership of certain assets is really limited through various structures and titling mechanisms, you find that the client's not as attractive as a lawsuit target. And it allows us, and it has allowed me in several circumstances, to either get rid of lawsuits before they're filed or get rid of them for relatively minimal expense once the other side understands that the prospect of collection is lessened, especially if you're dealing with somebody in a contingency situation. So first the basics, and this is some things that folks can do right away. You don't necessarily need to get complex. One of the simplest is how you title your ownership of assets. So if you're in a profession where you're exposed to a potential lawsuit, such as any professional advisor, you folks that we're joined with tonight, or we are as attorneys, there's a potential that hopefully we never deal with it, but the potential exists that a client could be upset or somebody could try to sue us. Our assets that we own personally in our own name are going to be exposed. But if you're married, like I am, and you have a brokerage account or some property, and you title that as a marital asset, which is tenants by entireties with rights of survivorship, that's a titling mechanism that's available only to spouses, to married folks. But if you title something as a tenants by entireties asset, that marital asset is not available to satisfy claims against an individual spouse. And this is poignant. Tonight, I just got off the phone. I was dealing with a client today who is in a situation where he's been sued and he had a judgment entered against him, and he's got a company, and he's married. He's been married for several years, and he's got this company, and for whatever reason, he owns at least a portion of his ownership in this company is owned in his own name, it appears, and not with his wife. And so if that's the case, then his ownership in the company is exposed.
We see that all the time, where someone will do their own organization, right? And they'll say it's me and my wife, and it's 50-50. So if it's a corporation and he's sued on a car accident, he loses his half of the company. Whereas tenancy by the entirety allows for joint titling and requires a suit against both husband and wife to reach anything owned by both husband and wife. Florida is very liberal with that. You can do real estate and personal property. There's certain presumptions even with real estate and bank accounts, where if you don't put anything, it's presumed tenancy by the entirety. Other states are different, are more complicated. Some states don't allow you to title personal property, TBE. Some states don't allow TBE at all. Other states are what are called community property states that don't allow tenancy by the entirety, but make both spouses liable for a lot of liabilities. So titling is very, very important. Eric mentions exemptions. These are called exempt assets. So in Florida, you can buy certain assets, and if you have no creditors at the time, and you later have a creditor that you didn't know about, that creditor cannot reach those assets. We've all heard of the homestead exemption in the Constitution, but life insurance, certain annuities, the 529 plans, a list of exemptions available in Florida of assets that are not available to creditors. And then you can create shelters for assets through entities. And typically we use the LLC, and whether you consider a trust an entity is kind of up for grabs, but also we use trusts in a variety of states and abroad for assets explicitly that are not exempt. So sometimes someone will come in with a huge 401k plan. We have doctors with these huge deferred compensation plan, but they have a substantial amount of assets and that are totally exposed, and there's no real titling means to protect them. So we use these entities to do so. We'll speak more about these entities in different slides.
we'll go deeper into entities and trusts. One distinction with trusts and entities, typically with an entity you transfer, but you may remain a manager. You have some degree of control. It's particularly in Florida, when you create a trust, if you're going to be the beneficiary, you're splitting the legal and equitable title. And so you're going to have somebody else who has the legal title, that's the trustee, that is technically in control, guided by the trust document, but that person's in control of the asset, and it exists, they control it for your benefit. Whereas an LLC or some other entity is typically a situation where you maintain control of the asset to some degree.
But it's not as strong.
But exactly, by maintaining control, it's a trade-off, and you give up some degree of protection.
Right.
Really tough. A regular, ordinary spendthrift trust in Florida is almost impossible to crack if it's set up properly. And that's a trust where, for instance, you set something up where you create the trust, you form it for the benefit of your kids, somebody else serves as the trustee, and you have a spendthrift provision to make sure that creditors can't get to proceeds from the trust. I've been involved in litigation where people tried to crack through those, and in one case we were involved. Frankly, one of the beneficiaries was literally a criminal. He's actually in jail, but nobody could get through the trust structure. I want to circle back real quick on titling this tenants by entireties, and just point out that the concept is simple, but it's often done wrong. What people will do is try to, for instance, add somebody to a bank account or add somebody to property, add a spouse, and make a TBE. It doesn't work. There are technical requirements to create a TBE holding. It's easy if you're used to it. For us, for Gary and I, we can look at something in a few moments. I really just want to see the documents. For this, rather than go through the details, I would just invite any of you, when you're dealing with that, or if you're dealing with that, if you're opening up a new account and you're not sure if TBE is offered or if you're going to be TBE, just pick up the phone, call us. That's literally one of those things we can generally answer in about 2 to 3 minutes on a phone call, and we're happy to field those calls just to make sure that you're pointed in the right direction.
We really want to be a resource to all CPAs. We don't bill for any of that or anything like that. An example of that would be if somebody before marriage had a big bank account and decided, oh, I'm just going to do a poor man's protection of that account to add my wife or my spouse. And that's not a TBE account.
It has to do with the timing of the titling. You really have to close the account, open a new account, and open it as a TBE account, have both sign off, and then move the funds into that account. Again, it's a simple thing, but people flub it a lot. So, all right, so asset protection with LLCs. Gary creates, how many LLCs have you created, do you think, in your career?
How many
Over
total?
1,000?
I don't know. Yeah, maybe 500 or something like that. Yeah, so LLCs are what's called a hybrid entity. So that's kind of a strange term. It sounds like a car. But where that's derived is on the slide here, inside and outside protection. So inside protection is what corporations offer. A lot of people point to the corporation as really one of the first asset protection vehicles. But really all it does on an asset protection side is insulate the owner from liabilities associated with the activities of the corporation. So what goes on in the corporation generally, unless there's some kind of fraud or bad acting, does not create liability for the owner. So you can contract for rent or whatever else you're doing in your business entity, and the owner is not liable for those debts, unless of course there's a personal guarantee or something like that. So that's inside asset protection. Outside asset protection is, I own the corporation, okay? It's an asset. How can someone take it from me and then take the assets of the entity? To prevent someone from taking it from me, that's outside. That's coming through me to get to the entity from the outside. And LLCs offer a degree of outside asset protection. So in general, the way an LLC works, and it's really the difference, they look totally different, but the real difference between corporations and LLCs is that if someone sues an owner of an LLC, the most they can get is a lien on LLC distributions. If someone sues an owner of a corporation, they can take the corporate stock. So I think the next slide goes into somewhat more detail on that, but that's outside protection. It's limited to, you're limited to a lien if you sue for somebody's stock.
And so the way I explain it to clients is, if you get a judgment against somebody, or somebody gets a judgment against you, if you own stock in IBM or another company, the creditor can seize that, just take it, foreclose upon that stock and take it from you. It's the same thing if you own stock in your own company. If you set up a business and you and two partners and you decide to become shareholders, somebody can take that interest. But with an LLC, that's not the case. You're limited generally to just the lien against any proceeds should the company make any distributions after that lien attaches, which, in the asset protection context, typically strategically you won't make distributions while you have a charging order attached.
Well, it's the idea that when you're in the litigation, you can posture your negotiations such that everybody knows that they can get a lien, but you're not going to make any distributions, so it triggers settlement. Here's the slide on charging orders, and it's just what we had said. It's like a lien. Now in Florida, and I think a majority of states, that lien is not foreclosable. In other words, the lien stays there until there's a distribution. You cannot transform that lien into a taking of the underlying LLC interest unless it's a single member LLC in Florida. And there are a few states that still allow for the foreclosure of the membership interest, but it's very limited. And like we had said, you can't force distributions. The LLC can accumulate money, and if nothing's paid, nothing's paid. There was a period of time where we thought that maybe if someone was suing for an LLC interest and they acquired the charging order, that we could attribute tax.
We have a question?
Oh, we do. Great. I love a question.
We have a question. So it's regarding a single member LLC, whether it offers liability protection or if a multi-member is better.
Single member LLC, whether it offers liability protection or a multi-member is better. First, a multi-member LLC is, in Florida in particular, is going to be better. And the reason for that is, you'll see a little bit lower in this slide where we say that not all statutes make the charging order the exclusive remedy. Some states allow for foreclosure of the single member LLC interest, and Florida is one of those states. You have to jump through it. You have to show a couple things, not jump through hoops. If you have a single member LLC in Florida, it's subject to foreclosure. Now, you can create a single member LLC under Delaware law or under Nevada law and operate in Florida, but if you're in Florida, you're still subject potentially to a court here applying Florida law to that interest, and that's an area that's called choice of law. That's an area that's heavily disputed by recognized experts in in asset protection. It's disputed among the courts, and court decisions are all over the board as to whether or not it's proper for one state to apply its own state's law to an LLC.
And we have a pretty good slide on that, actually.
Yeah, I think we'll talk about that. But
well, I also wanted to address, because it was kind of a general question, is liability protection better with the single or the multi? So the inside protection, like that's offered by the corporation for what goes on inside the operation of the LLC, that's fine. That's protected. The owner is not liable for that. But what happened is that, based upon like a few bad actors, courts beginning in Colorado started to eliminate rationalize away the justification for charging order protection for a single member LLC. It originally came from partnership law, which the purpose of which was, if I have a partner, then you cannot foreclose my LLC interest because then my partner's going to have a new partner. So that rationale, which really is kind of very indirectly related only to LLCs, was used to come up with the conclusion by a bankruptcy court that if you're a single member LLC, you don't get charging order protection. Someone can just take your equity, and that developed. And in Florida, it's actually now the statutory law. So I just wanted to give you a little more flesh out on that. Inside is fine. It's the outside protection of the actual LLC that's at risk when you're a single member.
That's right. The corporation and the LLC both offer similar protections for the owners against the acts of the entity. It's the individual's right to hold on to their interest in the entity that is different. And the corporation is exposed to foreclosure of stock. The multi-member LLC is protected, but for the charging order, and the single member LLC is potentially exposed. So it varies from jurisdiction to jurisdiction. So there are jurisdictions that protect the single member LLC by statute. And if you are operating through a single member LLC, that's where we're generally going to want to
If you have to operate through a single member LLC, you probably want to operate in a protective jurisdiction. We're just not sure what the Florida courts will do with that. But that also raises another issue. I know we're talking to CPA, so I know you guys like the practical side. The practical side is what you do is you take that inside protection and that outside protection for multi-member, and then you place it in husband and wife name, tenancy by the entirety. So you get both the TBE, the tenancy by the entirety protection, where you need a suit against both husband and wife as the owner of a multi-member LLC. And thus, if there's a suit against one spouse, there's nothing to get. If you win a case against both spouses, then you get the lien. And that's it. So that's kind of a practical way of looking at both the TBE and the LLC.
And we've also dealt with single member LLCs by having somebody, for instance, create a trust, or trusts for their kids, for instance, and then have that be another member. That will get challenged. I mean, at some point that's going to be challenged, but it's better than doing nothing. So hopefully that answered the question. Anything else on that?
Any other questions?
So, and again, comparing the LLC, and staying on this idea of.
Question. How about
oh, go ahead.
How about a single member LLC owning real estate?
A single member LLC holding real estate. You really have the same situation, except that it's actually, there's a little bit more risk, in my view, in Florida, because if you own real estate, I mean, it's better to own it in an LLC than not to. But the situation with the single member, if you're in Florida, is I could say, okay, I have a piece of rental property. There's no reason to put a homestead in the LLC. It's protected anyway. But if you put an investment property in an LLC, and it's a single member LLC, and say, okay, well, Florida doesn't protect the single member like Delaware and Nevada do, so I'm going to use a Nevada LLC. Well, what could happen is that may be, we would probably still do that, because you get threatened with suit, and you get an unsophisticated plaintiff's lawyer that sues on a slip and fall, or actually sues you individually if something goes wrong. And we say, well, you can't foreclose because this is a single member LLC created in Nevada. But a more sophisticated creditors counsel will make the argument that because the LLC is operating in Florida, and because it owns Florida real estate, it should be subject to Florida law with respect to the remedies available to creditors in Florida. And that's the potential exposure.
So the real estate issue is not an issue. I guess that's kind of it doesn't change. It's a valuable asset. Any valuable asset. It's interesting, we talk a lot, Eric and I, because I'm the planner and I'm the lover and he's the fighter. But we look at why, for instance, someone in Miami can't use a Nevada LLC and know that Nevada law is going to apply, because it's actually a different entity. I mean, the corporate words in the statute are different. I call it like a nickel, a Nevada nickel, a Delaware nickel, a Florida nickel, you know what I mean? But what happens in these cases is that the judge will sit through a trial or a full litigation and want to enforce the judgment. So you always have to look at it from the standpoint that the judge is going to get as creative as they can to reach into that LLC, because it was their judgment that needs to be collected on. I mean, if you really look at it, if I use a Nevada LLC and it says, if I'm sued, you can't reach in even if I'm a single member, why would that change because I'm in Florida? I for one, don't think legally there's a real argument there, but the reality is that the cases have developed to a point where we're not sure. We're not sure what the court's going to say. And if it's a bad actor who stuffed that LLC with something that they shouldn't have, they're probably going to get Florida law applied and that LLC taken.
And to let you know what a close call this is and how undecided the law is, Gary and I generally disagree on this analysis. I think that if you're operating in Florida through an LLC formed in another jurisdiction and you do something wrong that subjects you to liability, that if I'm the innocent party who's been injured here in Florida, I should be able to use Florida law for my recovery.
Even though you didn't form it in Florida.
And if you use the Delaware nickel analogy, so okay, well, it's a Delaware nickel, you got to use Delaware law. What I would respond to for that in litigation, I would say, well, you brought your Delaware nickel and you spent it in Florida. And if you're spending Delaware nickels in Florida, you're under Florida, you're here in Florida. It's kind of like, we'll talk about cryptocurrencies. You know, the Treasury is going to say you can't just create your own money, right? It doesn't matter what you call it. We're going to decide how it's going to be treated, and I think that's going to be but the analysis is all over the board. We've seen some jurisdictions like Colorado say you have to use Colorado law, and or excuse me, you have to use the law of the jurisdiction where the LLC is formed. And we've seen Florida, and we're going to talk about a case here in a couple minutes. You know, to give you an example of where Florida has disregarded the foreign jurisdiction and applied its own law.
And both and typically in the case of a bad actor, they'll do that. And typically in the case of a non-bad actor, non-fraudulent transfer case, this type of thing, they'll often respect the law of another state or country. And
we'll come back. We have a couple cases that are going to bring this point out a little bit more. I just want to show you that, you know, another issue where we talk about trusts and LLCs and some of the distinctions. You know, consider that with a trust and a spendthrift provision, that the funds that go out of the trust to benefit the beneficiaries will bypass the creditors under the spendthrift provision. But with a charging order, the creditor steps in front of any distributions. So no money goes out through distributions to the debtor without first going through the creditor. So a simple way to kind of distinguish those two.
All right, and we have another question.
Sure. Was there another question?
Yeah, there is. So in the case of a single member LLC multi-member LLC that chooses to be treated for tax purposes as an S corp or a C corp, is the same protection provided under those circumstances?
Yes, but interesting question. The tax designation and the legal designation are totally distinct as far as the law is or should be, I'll say, concerned. And this is an area that people do confuse, and I've heard this. I've actually had people tell me, well, my CPA recommended I should be a corp or an LLC. The LLC has protective legal mechanisms, and that doesn't change based on the tax designation. Tax is a totally separate designation. I say that with the caveat that Wyoming was one of the first states following this attack on single member LLCs to specifically write into their statute of protection for the single member LLC. This is a 2012 or 14 case in Wyoming, Green Hunter Energy. And in that case, a parent company was sued as the alter ego. It wasn't an asset protection. It wasn't a foreclosure case. This was just a straight up veil piercing case. So it was where the corporate entity, which was in this case a subsidiary, was sued, and they tried to get to the owner. In this case, it was a parent, through just regular veil piercing, piercing the corporate veil analysis. And one of the arguments that was made to pierce the veil was, well, the subsidiary is a pass-through entity that didn't file its own separate tax return. And the fact that the court considered that at all is just wrong. That decision has been lambasted across the country, and I'm sure Wyoming's hating it because now nobody uses Wyoming to form LLCs.
It's amazing. No one uses Wyoming after this decision.
So I give you that response with that caveat, but I also say that decision, which is now coming up on probably 4 to 5 or 6 years old, has received no support from anywhere else in the country as far as I'm aware.
No, but it also gives you a little insight into the fact that that was an inside asset protection issue. So something happened inside the subsidiary, right? And typically, if it's a corporate entity, you can't sue the owner. You can only reach the assets inside asset protection. So your only shot is to try to what they call pierce the corporate veil and get to the owner. And then once they got to the holding company owner, they can get to all the other subsidiaries or whatever they were trying to do. And so you just have to keep in mind that the plaintiff's lawyer is going to make an argument, whatever they can do, they're going to do. And if the judge really wanted that argument to succeed, he's going to say, oh, you're disregarded for tax purposes. I'm sure you guys are familiar with that. Well, I guess you're disregarded for legal purposes. Now, it's idiotic, but someone made that, I can tell you, someone made that argument.
And the court bought, the Supreme Court of Wyoming.
It's amazing. It's amazing.
It was really, it's a bad decision.
Yeah, it won't, it's very unlikely to happen with anything related to Florida. So no, it does not compromise the legal protection.
And we have a note here, LLCs are generally easier to maintain than corporations. They have less administrative and ministerial requirements. You don't require meetings. But the same veil piercing, as we saw in Green Hunter, we've discussed, separate from the foreclosure issue, piercing the corporate veil is the same with LLCs and corporations, but it's a very tough standard in Florida. Florida basically follows, there's 2 lines of cases. One, some states say, well, if the corporation or the LLC, if the corporate form is not followed such that the entity becomes an alter ego of its owners, so there's no separate legal distinction, then potentially you could pierce the corporate veil, hold the owner responsible for the acts of the entity. We see that through, not like commingling funds is a huge one, using the company bank account for personal use, not having your meetings and keeping minutes, not having proper documentation and so forth. Florida subscribes to a higher standard, and so does Delaware and so does Nevada, other popular corporation states. And the same would apply, when we look at these cases, because LLCs are still relatively new. When we don't have specific law for an LLC in the litigation context, we'll then go to the corporate statutes and the corporate cases and look and see what they do. And what Florida says is that in order to pierce the corporate veil, you have to show all those alter ego components. You have to show that there's no separate legal existence. You also have to show that the entity is being used for fraud. Very tough to show that in Florida. The argument gets made. I've made the argument myself. I've succeeded on it. Frankly, I've succeeded where it probably should not have, just because the other side didn't defend properly. I was going after criminals, but it's a very tough standard to pierce the corporate veil in Florida. And that's the issue with the taxes where we saw it before.
And we have one more question, and it's what would be your recommendation to hold Florida investment property?
Recommendation. Okay, that's perfect, because we just pulled up the slide. This is where to form the LLC. Passive investment property. I'll let Gary field this because you do the planning on this.
Yeah, every day. So do you mean like investment accounts and real estate that you don't live in?
Yes.
Okay. So what we typically recommend is that the client form a holding company, okay? And that holding company does not do any business. So we want to avoid the issue of having a Florida court say, you came here to do business, we're gonna apply Florida law. Of course, it's always a possibility, but if you don't do any business, it's unlikely. So we would say, okay, let's form a holding company in Delaware, which is very protective. Let's have husband and wife own it, and then if we want, we like to add a couple of members. So maybe we have the kids. If the kids are not of age, we can create a couple of trusts for the kids. And so we have a multi-member Delaware LLC. And then that Delaware LLC holds each property, or to the extent the client feels comfortable, to maybe 2 in 1 LLC, but we like to segregate each property in a Florida LLC. So you have your holding company, owned husband and wife, with the trusts for the kids, and that holding company owns Florida LLCs, each with an investment property, and then all the accounts, all the brokerage accounts can go into one single LLC because they don't create any liability. There's no insulation you need between your accounts, like real estate. We insulate the real estate in these separate LLCs. That's a very basic format that works very well. To this day, 24 years of doing this, I've never had one of these breached. Now, if someone's in a very high risk industry, we actually do this and then we do more. So what we may do is this, and we may do an offshore trust. Or if husband and wife titling's not available, well, then we're relying on charging order, right? So if we don't want to rely on charging order, which allows for a lien, so we don't want our distributions liened in any case. If we have a single person, or maybe a single person with kids, we might create a foreign trust, or we might create a domestic asset protection trust, which we'll talk about here in a second, for the individual. And that says that if I'm sued, I don't own my exposed assets. This trustee in Nevada owns my exposed assets. So have fun trying to reach them. And those assets are basically 95% of this holding company, this Delaware holding company. Does that make sense?
So all the Florida LLCs will be single member LLCs.
Yes, but there's no exposure.
Okay.
Because the single member LLC still insulates the owner from what happens inside the LLC. And the single member LLCs will all be owned by a multi-member LLC. So owners, the individual, if they incur liability, they don't own a single member LLC. They own equity in a multi-member LLC. And that multi-member LLC owns these single member, they're subsidiaries, these LLC subsidiaries for real estate.
Okay.
So the issue with the single member is the potential exposure if I own a single member LLC, I'm the sole member, I go out and do something wrong and I get sued, or if I have a business and that does something wrong and it owns a subsidiary company, then if there's only one member and that member gets sued, the creditor can potentially take the interest in foreclosure. But what Gary's saying is by creating the holding company, that holding company is not going to go out and get sued by anybody. The holding company is not going to run over anybody. It's not because your holding company is not going out on a Friday night getting drunk, causing problems. Yeah, you can imagine just like this LLC, kind of like the old commercial with the, conjunction, junction, what's your function, right? So the holding company is just sitting there being owned by several members. And so you're never going to have a situation where one of the subsidiaries is being foreclosed, or where that interest that the holding company owns is going to be foreclosed upon.
Okay, any other questions? All right, there's no more questions at this time.
Okay. And we have some notes here about where to form the LLC. Oftentimes there's good reasons just to do it right here in Florida, not get too complicated. Kind of depends on, you know, what you're using it for. If you're going to be in business, if it's just a passive investment vehicle, then maybe there's some reason. If it's going to be single member, you want to look outside. But if you're just creating a company and you're going into business with a partner and you're going to do business here in Florida, I'm not sure there's any reason to go anywhere else, even though Nevada and Delaware are popular places. You just, here in Florida is going to be just fine for a multi-member business in most cases.
In most cases, yeah.
If you have privacy issues, and there's legitimate reasons. We represent somebody who was in a horrible marriage relationship, and they were business partners and broke up. And anytime this poor woman would try to do anything, her husband, who was, yeah, I don't know what the legal term is, but I think the legal term is dirtbag, would just harass her and harass the business, harass the clients. So she didn't want anybody to know that she was starting a new business. She had a good reason. She didn't want anybody to know she was the owner of this business. And so we go through Delaware, and Gary set it up with a Delaware holding company.
And it's totally anonymous, Delaware.
Yeah, Delaware. If you go on Delaware and you try to find out who the owners are, all you get is the agent for service of process, the registered agent. Thank you. And then we do offshore. Gary does offshore entities. Nevis is a popular area. He's written part of the law in Nevis on that, and that's another popular spot for LLCs for certain.
If it's appropriate.
If you really wanted to create a protection and for certain types of assets. So we talked about this notion of choice of law, and that's, you know, if I'm in Florida and I'm dealing with a Delaware LLC, can I apply Florida law, and or which state's law applies? And while the laws are often similar across states, there are differences. There's nuances that make one sometimes more favorable than others, such as the ability to foreclose. Sometimes the statutes of limitations are different. So, you know, I think the best way to kind of pull this out, and we'll talk about this, is through a couple case examples, and we mentioned these. And the first one is this Wells Fargo v. Barber. This is a 2016 case right here in our home area of the Middle District of Florida. And you want me to do the background on it?
Sure.
Okay, so what happened here is Miss Barber owed a lot of money to Wells Fargo, and she had some money, not enough to pay for the debt, but she had a big homestead. So her first mistake is, for whatever reason, she sold this big house.
So the homestead's protected.
Yeah, homestead is ironclad. That's like the bomb shelter. If you ever have a client who's being sued and on the run, it's the O.J. Simpson remedy, right? So I can go buy a homestead. There's some requirements, by the way. People still screw that one up because it can only be, you know, if you're within a municipality, it can only be limited by, you know, half acre or whatever, half acre.
Half acre, yeah.
There's some other requirements, but it's pretty broad. Florida's got the broadest homestead protection in the country. But Miss Barber, for whatever the reason, sold her homestead. And Florida's homestead is so strong, you could actually take homestead proceeds. You could sell the homestead. You don't even have to, I mean, it's safer if you're going to do this and buy a new one, is to put it into a designated account or use a third party. But you don't have to even go through the formalities of like a 1031 exchange. You could just sell the homestead, designate those funds for a new property, and buy the new property, and you're still going to be protected. But she did, first of all, she did something we always recommend against, and she just did a lot of movement with money. She created different LLCs and moved money into this one and out of that one, and sold property and bought property. It was all while she was under this threat of a lawsuit, and in a lawsuit with Wells Fargo.
And of course, it was a huge debt.
Yeah, it was. I think it was, you know, $80 million or something. And she ended up taking some of her homestead cash, and she bought the homestead, and she took other cash and she put it in an LLC. Well, she put it in a bank account, and then the bank account was owned by an LLC that was a Nevis LLC. It was an offshore LLC. So you think, okay, well, I'm safe. Nevis protects the single member. It's Nevis law. If you want access to the account,
but it was
go
a
to
fraudulent
Nevis.
transfer.
Gary says it was a fraudulent transfer, and what that means is that you're evading your creditors, you're dodging a creditor with an intent to avoid the creditor. But she even had an argument to defeat fraudulent transfer, and the argument would have been that she's taking unexposed funds. She's taking exempt dollars from my homestead, and I'm putting them aside. They were never available to a creditor anyway, and I'm going to take those funds and I'm going to put them into an offshore entity.
Which is crazy.
Had she put it in an account offshore in the offshore entity, she may have been better off. But she stayed here in Florida, and so Wells Fargo, of course, they go to court, and Wells Fargo makes the argument, well, Miss Barber owns a Nevis LLC, but she's here in Florida. The LLC interest is an intangible interest. It's wherever the member is, and since she's here, the interest is here. The court has jurisdiction over that interest, and the court should apply Florida law. Under the choice of law doctrine, the court should use Florida law, not Nevis law. And Florida law allows you to foreclose on a single member LLC, provided you can show that that it's unlikely that you'll be paid from a normal charging order within a reasonable amount of time. And given that Ms. Barber owed Wells Fargo about $82 million, and she hadn't paid any of it, they were able to convince even that judge that they weren't likely to get paid anytime soon. And so what happened is the court agreed. The court allowed foreclosure of the Nevis LLC interest, applying Florida law because Ms. Barber was here. And courts will use, in that case, they use the fact that she was here and the interest was attached to her. I've seen courts use the argument, well, our public policy is to allow foreclosure of these interests, or our public policy allows, and we'll talk about a case later with a trust.
There's a temptation because she basically kept all the cash in Florida. So
bingo, that's the other problem.
Yeah, so I mean, the judge has the judgment for 60 whatever million dollars, sees the cash in the, some Merrill Lynch account, and the defendant says, well, no, it's owned by Nevis LLC. I mean, do you really think that the judge in that case is going to care who owns it? The judge is going to lock that account down and look right through that LLC if there's any argument at all to do so. This was an odd case because she had the homestead protection and blew it, which was idiotic. But it's interesting to see what happens when you have a bad actor and there's an argument on collection. Typically, the court will take every effort to collect. We have another case here, this JP Morgan case. That's a Colorado case, if I recall.
Yeah, that was.
Yeah, well, correct me if I'm wrong. So that was a defendant in Arizona who lost a commercial litigation suit, and that collection was then started such to take a Colorado LLC interest which held Colorado property. So in that case, a lot different. It seems very similar, but it's a lot different. It's not a bad actor, okay? And you're moving to a state that does allow for somewhat of a protection of that LLC interest, and the Colorado court is very.
There were competing interests in that case too. It was competing creditors, so that's
yeah,
why
that's true. That's helpful too.
You had creditors competing, where one had filed and recorded a judgment in Arizona, and another one had done it, and I forget what the other state was, maybe Illinois, where the debtor had an interest. And so the court was forced with saying, well, who's in the race to the courthouse, who prevailed? And then you were on track to.
Well, no, they landed in Colorado, and the asset was in Colorado, and the LLC's Colorado. Unlike in Barber versus Wells Fargo, you had the asset in Florida owned by a Nevis LLC. You had a Florida court, and you had a bad actor with the judgment in Florida. Here, the judgment was Arizona. Colorado court says, no, this is our statute. I'm going to follow the statute, and I'm going to apply the protection. You can't reach the asset.
Well, and they recognize that the Arizona statute should govern the Arizona interest, and I forget the other state, but it may have been Illinois. The other state's interest should govern that interest. And then when the debtor was in Colorado, the court said, well, we're going to, wherever the LLC was formed, that's the state that we're going to rely upon their law to determine the effect of your recording and whether or not you can, what your remedies are under the statute.
And there's a couple other cases that are very that are very similar.
And
This is an Alabama case.
McClure, what's interesting there is the McClure, one of the parties in McClure actually cited that Barber case in Florida, and the Colorado court said, you know, we know about Barber, but we don't agree with it. We don't think people follow. We think Barber got it wrong, and so we're gonna create our own law. So now you have the state Supreme Court of Colorado expressly disagreeing with the rationale that was relied upon by the federal middle district court in Florida. So again, this isn't a simple issue. And so, you know, we have some suggestions when you're dealing with this. You know, again, one is just, if possible, avoid the single member. And if you can't avoid the single member, then just be careful on how you use it. There's certain states where a single member is going to be better off, and we've pointed those out. And also be aware that, you know, the rationale, I don't know if we have really time to dig into this, the rationale and how the single member was first cracked, but it went back to that innocent partner rationale from partnership law. And the first single member LLCs that were cracked were because it was just one owner who was a bad actor. And so our thought is, what if you had two owners in an LLC, and especially if one maybe has a nominal interest, or if they're both bad actors, will court crack through those? And potentially the answer is yes. And that's the answer with any of these is, you know, we go by what the law that's in front of us, but we're also trying to predict a little bit where things will go. And we try to take that into account when we're doing planning. And so nominal interests, as we mentioned earlier, creating a trust with a 1% interest or 5% interest, better than not doing anything, but we're not going to tell you that it's 100% either. So let's talk about DAPTs, Domestic Asset Protection Trust. So the Domestic Asset Protection Trust refers to the self-settled trust. I want to set up a trust for myself, and what you need to know about these is they are a unique trust because in a traditional trust you had the separation of the legal and equitable title.
Well, you still do.
With two different parties. Yeah, you do.
It's that you're right, but traditionally under English common law, if you form a trust, you really have to form it for the benefit of someone else. So if you form a trust and you form it for yourself and your child, in Florida, for instance, which follows the English tradition, if you're sued, the trust assets that you could benefit from are available to the creditor. So trusts aren't really great historically entities to create asset protection for gifts to yourself, for transfers that benefit you. So in the 90s, several English-based colonies around the world said, you know what, there's a demand for a trust where someone could put the money in trust with us in our country, and they could be a beneficiary of their own trust, and we're going to write the law that says the trust assets are protected, even if this grantor beneficiary is sued. The states didn't do that until relatively recently, so tons of money went offshore because of that. And now we have 16 states that allow you to create a trust for yourself or for yourself and other people. And then if you're sued under the trust law, the trust assets that would benefit you are not available. They're self-settled. You create your own trust, asset protection trusts. You just have to keep in mind that, you know, did you read the article in the Bar Journal? Bar Journal about 4 months ago had an article arguing that self-settled asset protection trusts that are formed in the United States are much stronger than foreign trusts. I do not think that's the case. I don't think that's the case. Only because the law is very similar. The law protecting your interests is very similar. But like what happened with Barber, has happened to some extent already with domestic asset protection trusts, in that it's very tempting for the courts to try to act on assets in the states, whether you think they're protected or not. So we often do both, a combination with clients, but it's very hard to get to argue against the practical protections of someone in a different legal jurisdiction holding your money in an offshore trust versus someone here holding your money in a domestic trust. I mean, Eric could argue, you know, there are some advantages litigation-wise because, you know, we have the full faith and credit doctrine in the United States, and maybe that would be a little somewhat stronger if, in fact, you formed your trust in the United States. But as you'll see, when we get into some of these cases, the courts are pretty tempted to reach into these domestic asset protection trusts, whereas offshore, it's just a
And here it's useful to walk through a couple cases and just show you examples of how these how they've been attacked and what has been, you know, what arguments have been successful. Also understand, because there's only a limited number of states, what is 16, it might be 16 states now, not in Florida. Florida does not have a self-settled asset protection trust. So if you're in Florida and you decide, well, okay, can I go to Nevada or somewhere else and form one of these trusts? You may want to reconsider based on what some of the experiences have been. So here's the first issue with a domestic asset protection trust, and it's if you set up the trust with a bunch of assets that you still control and you're in a jurisdiction that does not recognize the self-settled trust, you've got exposure, and that's what happened in Huber. Gary, you want to give this Huber background a little bit?
Sure. Huber is our what we call our seminal case for DAPS. It's the same story over and over. The courts go through litigation and they want to find these assets to enforce their judgment. So Huber was a fairly large developer in Washington State. He had some trouble. I think was somewhat unclear. It is a bankruptcy case, which also weighs against him. But I think did you get a lot of clarity on whether he did fraudulent transfer? It wasn't that clear.
No, all we really know about Huber is that his assets, that he had real estate, he
ran into some potential problems and went bankrupt.
And he owned all these things in Washington.
Right.
But
he kept
filing
them
bankruptcy, but we're actually speaking live at this, we're doing something with the Orange County Bar on Friday at their big, you know, they do one every 2 years, this big seminar, and we're on a panel. We're leading a panel, and there's a bankruptcy judge. It'll be interesting. So we're
a panel of us.
So it's us and the bankruptcy judge, and we'll be talking about some of this because we've done a whole seminar basically that says use asset protection instead of bankruptcy, but you don't. Bankruptcy is where asset protection.
So he went bankrupt, which was likely a mistake. But besides that's a huge issue. But in terms of what you should think about with these asset protection trusts is, Huber forms a trust. The trustees in Washington State, it's like his kid, and all the assets are in Washington State, and Huber's in Washington State, and the trust is in Alaska. So right off the bat, there's no connection to the jurisdiction of the trust. Now, years ago, we wouldn't have really said much about that, because if you write a document, the document says this document should be interpreted under the laws of Alaska, it was kind of followed. But now it's much more controversial, and Huber basically got everything taken from him, because you really have to set up a connection between the trust, the assets, the grantor, and the trustee. They really all should have some kind of connection to where you form the trust. Washington State, even, the problem with the bankruptcy court is eventually they're writing the opinion, they can't really make it work because it doesn't really make sense. They're using the Alaska nickel. And they say, well, we have a public policy concern. Public policy wasn't used except for mass murders before like 2004. But now to reach assets, we have a public policy, bankruptcy has a public policy concern about people being able to protect things with these domestic asset protection trusts, so we're taking everything. So that being said, there is an argument though that says, so if I want to do a Nevada or a Alaska or Delaware domestic self-settled asset protection trust, and I open the account in, like I use Nevada for the trust, I open the account in Nevada, I use a Nevada trustee, and all my activities related to Nevada, and my client gets sued, the grantor gets sued in Florida. Well, you may lose the suit in Florida, but I think a litigator like Eric is still going to be forced to go back to Nevada to look for those assets, domesticate the judgment, but Nevada's not going to allow that to be breached. I think it'd be very tough.
I've defended a Nevada trustee. If the Nevada trustee stays out of Florida and you can keep them outside the Florida court's jurisdiction, you've got a good chance of holding that thing up. And we were able to do it. I had a case here exactly on that issue, and it was a Nevada trustee that owned LLCs. So the argument that was not made by the other side that I was worried about but didn't have to deal with was sort of this alter ego disregard the entity. Well, the assets are here and the debtor's here, you know, the beneficial owner is here, and so we could just disregard the trustee. But what the other side did in this particular case, this was about a year and a half ago, was tried to sue the Nevada trustee, and the Nevada trustee was actually a member of a holding company that owned assets here. So they tried to sue the holding company and tried to sue the trustee here in Florida, and we argued and objected to it on jurisdictional grounds, and we were successful. So they weren't able to actually get to those assets. So if you keep the people out of here, out of Florida, or whatever state you're in, and you know, preferably keep the assets, but at least keep the people out. You know, in Huber's case, if he'd have kept his trustees in Alaska, he may have had a much better shot at having this stand up, and certainly having assets or something else in Alaska.
Especially if you didn't go bankrupt.
And not going bankrupt. And that's our segue into our next case, which is Mortensen. And what you need to understand here as well, you know, this is another issue of bankruptcy, is there's a particular statute when the bankruptcy code was rewritten. They wrote a statute as part of the fraudulent transfer statute. The bankruptcy court wrote in a provision that says that any transfers into a self-settled trust that are done to avoid or defraud a creditor can be unwound for a period of 10 years. So a normal fraudulent transfer. Normal fraudulent transfer is about 4 years. Of bankruptcy, it's 2. But for a self-settled trust, the rule makers in 2005 so hated the concept of the self-settled trust, which was pretty new. I think it was only 2. Yeah. I think it was Alaska and one other state in 2005 that had that statute. And so they wrote in a provision in the bankruptcy law that says you can unwind transfers into a self-settled trust for 10 years. So with that, let's talk about what Mr. Mortensen did wrong.
Yeah, well, so he had a divorce issue.
And by the way, he lived in Alaska. He was an Alaska guy.
He was a mountain man. He was a mountain man who was a know-it-all. So what you run into, as you CPAs are well aware, you have a mountain man, and the mountain man says, I'm just going to do what I'm going to do. So he has a divorce proceeding against him. And the wife's counsel fails to attach assets inside the statute of limitations for collection. So Alaska, I believe, had a 4-year statute on collection. She didn't get to the assets. She did not attach. He was in the clear. He files bankruptcy and extends the statute to 10 years and loses the assets.
He had the self-settled trust. Had he just kept the trust, defended with what he had, no quick moves, had he done nothing, just sat on his self-settled Alaska trust in Alaska with his Alaska property, he was home free. And he files for bankruptcy, and it's like all of a sudden just opening up the door and inviting the creditor in to come take all your stuff. It was his wife in that case.
I'm sure she did too.
Well, he probably deserved it. I don't know, Mr. Mortensen, but let's talk about another issue that's come up recently. And this shows you where courts really, you look at anything, and I've done the litigation, you look at any place where, years ago, we were suing a limited liability partnership when I was in the Vice practice in Nevada, and we were suing a member of this limited liability partnership. We knew he was a deadbeat, but we could get to the other members, and they were doing business in Nevada. It was an investment company. They just didn't file they just had to file that little piece of paperwork that says they're registered as a limited liability entity in Nevada as a foreign entity. They didn't do it, and by not doing it allowed us to get to the other partners in that partnership. Here is a situation, a recent case out of Alaska, where Alaska has this statute that allows for the self-settled trust, which is a unique mechanism that's not allowed in many other states. But the statute also has specific administrative requirements with which you need to comply, and you have a situation where the grantor or the settler of the trust is required to complete an affidavit prior to funding the trust and failed to do so. Now, frankly, this case just popped up. It's a recent case from 2017. I did an overview of it and pulled out this important part. I didn't look at the background of what happened leading up to the case. Sometimes I'll get curious and I'll go and I'll pull the underlying documents and read, because I'm like, what happened that Alaska would not recognize its own trust? I have nothing but speculation, but I suspect this guy did something more. I suspect that they irritated the court, and a creditor jumped all over this and said, well, he didn't follow what he was supposed to do. Some courts will say, oh, no big deal. We're not going to blow a whole trust because of this. But here we had a situation where that's exactly what happened. We saw something similar, by the way, in Tennessee. Had statutory requirements, and this was a regular trust, not a self-settled trust. Didn't follow the statutory requisites for establishing the trust and funding the trust, and blew it. And in that case, it involved fraudulent transfers. So the lesson here is if you're going to engage in one of these protective mechanisms, especially one that's on the periphery, like a self-settled domestic trust, make sure you're dotting every I and crossing every T. Anything else you'd add on that one?
How could I add anything? That was amazing. Dotting every I and crossing every T.
I had to stop and make sure I got the I's and the T's uncrossed. Yeah. Okay, here's a Tennessee. Actually, here's the Tennessee case I referred. Yeah, there was more to this. This guy, he creates the trust for his kids, but then he says, I'm going to be the trustee, and I can put property in, take property out at will. I can pay myself income, which was a violation of the trust statute. And this was just, I don't know, maybe not so surprisingly, I get calls like this. I get calls from professionals, and I welcome them. I'll talk to you. Everything we talk about is confidential. But if you're doing something, you're like, wait a minute, I think I found an angle to get around this, and you're like, I just need to do this or cover myself here, please give me a call, because sometimes courts are pretty smart and the law is pretty smart sometimes. And here's a perfect example where a guy says, well, I'm going to set up a trust for my kids and they'll be the beneficiaries. He writes up this fancy document, and then he just includes provisions like I can just put stuff in and take stuff out whenever I want and pay myself.
We've never gotten a call like that out of South Florida or anything like that.
And the court see right through it. The court just called it a sham. I don't know if the court called it a sham, but that's what it was. The court knew what it was. It was a sham, and used the fact that he didn't follow the trust statute. Similar to Alaska, here's one where the court said, well, the trust statute doesn't allow this. That's an easy way. You're just giving, basically, you're tossing the court like an easy way to get there. But I'm pretty confident that even without the statutory requirement, the court would have seen right through that. So again, follow the formalities, make sure you're complying with what the requirements are. And a lot of it has to do with intent and motive. And then not to be a total downer and rain on the self-settled trust parade, there are times that it works. And in fact, it involved a Florida resident who used a Delaware DAT. This was actually a case where the person who set up the trust for, it was a self-settled trust, but also had children as beneficiaries. And here's what this person did that was really smart. They had some loans with Trustco, and they updated their financial information with Trustco. They went to Trustco and said, hey, I've got these new trusts that were established. Just want to let you know what my financial situation is, which is what you really should always do, because what you've done now is you trigger the statute of limitations. If they later, if the bank says, hey, we never knew about these transfers, we never knew you changed your financial situation.
Yeah.
You find a way to do it. Sometimes you do it real obvious, especially some people just don't think anything
They
bad's
always
gonna
have
happen.
another year if they don't know.
Yeah, there's a discovery rule that attaches to these fraudulent transfer cases. So even if I don't find out for a long time, if you've hid it from me, or if I had no way to find out, I can, you know, kind of like the 10-year rule in Mortensen, I can jump on this years later. But the person in Trustco was a Florida person who told Trustco what they were doing. It was totally above board. Everything was on the level. And from everything I can read about that case, this is a perfect example of somebody doing everything right. I'm going to take some of my chips off the table today, put them aside for me and my kids for later. I'm letting all my creditors know, no hiding the ball here. And I'm going to use Delaware law with a Delaware trustee, some accounts in Delaware, some stuff in Florida. And when the creditors challenged it, they tried to sue on fraudulent transfer and they lost. Now, interestingly, I don't know if they made an argument. I couldn't see anything in this case where they just kind of made the Huber argument. Well, Florida doesn't recognize self-settled trusts. I'm not sure why
And
that
the court didn't want to really go there either. So the Delaware court applied Florida statute of limitations because it was just clearly had passed. So there was no issue, no claim.
So there's a great case where somebody did use a self-settled Delaware trust and used it in a proper way and was successful with it. And we come to we'll probably talk about this case, you know, California crazy. That's all this case is. Kilker v. Stillman. This is a guy, he actually did some things right. He set up a trust when he had really no claims on the horizon. He got sued in 2008 based on some defective construction work from 2000. 8 years had passed. He set up the trust, I think, in 2004. So the trusts were long since established in Nevada. But the California judge just didn't like him. First, he got sued. He agreed to pay the plaintiffs in a settlement and immediately reneged. And he was holding his California real estate in this Nevada self-settled trust. And he when he testified, he said, well, I don't have any assets in my own name. I did asset protection in Nevada, and so you can't touch me. And I think he started actually humming the soundtrack to the MC Hammer album, Can't Touch This. And nobody was impressed by that, including none of the people listening to me now.
The court wasn't impressed at all.
We need to get a little music for, like,
We had
MC Hammer Can't Touch This.
When we first started.
And I apologize, Andrew. We will have the MC Hammer music the next time, or some theme music to go along with it. But the takeaway from this is that they can work, but here the guy, you don't sit in court. You say, well, I did some planning. You do asset protection. You got to be subtle. There's a subtlety to it. And he just went to court and said, I don't have any assets. It's all locked up in asset protection, so you can't touch me.
And then he reneged and was nasty, and they just found a way.
And the court said, well, yeah, but those trusts hold California assets, and the court found a way to get to the assets. And really, this is an outlier case. People will talk about it as an outlier case, but regardless of the fact that it's an outlier case, we can't ignore it because it shows what can happen, at least if you go California crazy.
Sounds like fun, California.
All right, so yeah, I want to make sure we leave plenty of time for we'll probably break and get into our cryptos there. So, you know, what are we going to recommend here? You know, what are the takeaways? And first, oh, go ahead. Great.
About 12 minutes or so. At 5:45 is when we're going to go to break. So kind of like plan it that way. Does anybody have any
Perfect.
questions?
All right, you wake everybody up.
And if we have too bad we didn't advance notice, we could have sent some wine down.
We sent better. We sent books.
We sent books.
Yeah.
Everybody's
So,
got the
all right. So, you know, what do creditors do to get access? You know, and we talk about this, and the reason we talk about how you, and go through these cases and say, well, how have these things fallen apart? What have people done wrong in the past? You know, it's like strategizing for anything. It's like going to war or in sports. Say, well, this is what they did the last time, so let's try and cover this. And so this gives us, you know, we use these cases and we have takeaways that are lessons from the cases. And first, you know, the excess control. That's Huber. That's that Tennessee case. This is the circumstance, you know, that's, you know, Barber with the LLC. This is, I'm going to set up something separate, but I'm going to put all my assets in it, and I'm still going to control it. And invariably, if you're a bad actor and you're doing that, the more there's a
clouds have
trade-off.
already formed.
Especially if the clouds have formed. There's always going to be a trade-off. One, there's sort of this relationship, an inverse relationship between how bad a situation are you in when you do your asset transfers. If the skies are clear, more likely you're going to have success. Another element is the element of control. How much control do you really still have? If you really have created a trust, like an offshore trust with an offshore trustee, and your control is now limited, much more likely that's going to hold up than an LLC where you're the manager and sole member and you control everything here. If an entity or a trust or a corporation or an LLC lacks economic substance, we talked about this earlier, that's the alter ego situation. So you want to make sure that whatever you use, whether it's a trust, you're following the trust document, you're following the law of the jurisdiction where you form the trust. If it's an LLC, make sure you are following, you know, what are really minimal procedural ministerial requirements for LLC, but make sure you're following them. Make sure you have minutes to reflect what you're actually doing with the company. We talked about shams. One of my favorite sham cases, and we talked about the recent one, but there's one involving the Bilzerians. They were threatened with jail time here in Florida. They set up revocable trusts. They set them up for each other where they were the only beneficiaries, and husband and wife were the trustees of each other's trusts. And they were sued by the SEC.
And they initially put up a big fight.
Yeah.
Until the court realized the whole thing was just truly a sham and threatened to put Bilzerian in jail. And he said, I really can't go to jail. What the court can do sometimes is force a turnover of assets. In other words, if there's a ruling that says you must pay Mr. Y, you have to pay Mr. Y. If you don't pay Mr. Y, the court can fine you in contempt and put you in jail until you pay Mr. Y or it becomes impossible. When that prospect was presented to Mr. Bilzerian, he paid apparently about 12 minutes. The check would have been cut. The funds were available because he couldn't deal with the fact that he could go to jail. So you don't want to be doing shams. It's just going to upset the court. You want to plan on a sunny day.
And so, you know, when we talk about the brute force method, a lot of times you see this in connection with a government claim or a very high dollar claim. The cases we have here, Lawrence, that actually involved Bear Stearns, but Mr. Lawrence filed bankruptcy and ended up spending about 6 years in jail because he created offshore trusts and he was ordered to bring the money back and wouldn't do it.
And by bankruptcy court.
By a bankruptcy court. So how this looks is you'll have a debtor who is ordered, you know, the creditor will say, you need to judge, we want you to order them to repatriate or bring back the assets. And some courts will say, well, if you want to go after an asset, you have to go to that jurisdiction and go get the asset. But you have some courts that'll, you know, or the creditors will make the argument, well, the debtor has moved the asset offshore, but the debtor still controls the asset and they can bring it back. And they need to do that. They need to repatriate the asset. And we've seen courts that have ordered repatriation of assets. And recently there was a middle district case where somebody was ordered to pay over funds and threatened with contempt. And what that means is that a judge can say, I'm going to fine you in contempt of court, and you can purge your contempt or essentially rid yourself of that contempt hanging over you if you return the assets to the court. But if you don't do that, then when you come back, bring your toothbrush and be prepared to turn yourself over to the custody of the United States Marshals. It's usually federal courts. Mr. Lawrence did that for 6 years. Grant was an IRS case where Miss Grant
But did keep his money, by the way.
Lawrence kept his money. There's a couple other cases where people have been able to keep their money, but they spend time in jail. Bill Zarian decided he liked the freedom better than the money.
That's right.
But to demonstrate the difference, because what the response is, and we're going to close out here in a minute here, but the response is that the debtor will say, well, I don't control it. Somebody else is in control, a manager, a trustee, and so it's impossibility. And impossibility is a defense to contempt, but it's got to be real impossibility. It can't be self-created. And so the comparison here is Lawrence, where you've got a guy who creates a self-settled offshore trust, puts all his money there, versus the IRS versus Grant, where her husband created the trust offshore, set up the trustee, set up the protector, and then he passes away, and the court was going after R-Line Grant, and that was it was South Florida, down by you folks. And I think it may still be ongoing, or they may have settled, but they were chasing her for a while and keep going back every once in a while. It's a pretty colorful case, and but there the court did not incarcerate Miss Grant because she said, look, I've tried and I've tried. I've asked the trustee send money.
Well, her husband, it wasn't self-settled.
Yep, she didn't
created.
Right, her husband created it, so it wasn't a self-settled. It wasn't self-created impossibility. And so, she said, look, I've done the best I can do, but I can't get the trustee to bring the money back. Finally, if you show good intentions, if you have other reasons, we always advocate whenever you're doing planning, have legitimate business reasons and personal reasons beyond just simple asset protection. Although, if the trade-off is, look, I can go blow all my cash, or I can sit on it, leave it exposed, or I can save it for a rainy day. Saving for a rainy day is a pretty noble cause, but the courts don't always see it that way. You go back to Kilker, where they stripped him of his assets because he did asset protection. The irony is Mr. Kilker would have been better off when he went to Nevada, rather than hiring an asset protection attorney, probably just spending his dough at one of the casinos there and losing it all. At least he would have been comped a few drinks. That's the reality. He could have gone and blown it, and the court would have done nothing. But because he went and he decided to save it for the long haul, he got penalized for it because he was pretty frank about it. We'll wrap up here. Some of the keys, and by now this is gonna sound a little redundant, hopefully to you, because this is what we want you to take away. Asset protection beyond the timing. When we're talking about this specifically domestic asset protection, where are the people? Where is the trustee, the manager? Where are you doing business? That's a consideration that we're going to want to talk about. What types of assets and where are the assets? And then the control issue, the bankruptcy issue, and finally, as we harped on here in the last few slides, don't be egregious. Come up with 3. We did a whole seminar where we called it "Don't Do Asset Protection," and we're asset protection lawyers. But it's the message that you're sending out to the courts. And do we have any questions? I know we're going to break here, and we'll get ready to start our little discussion on Bitcoin and cryptocurrencies while they still have value.
Yeah, that's the exciting part.
How are we doing, Andrew?
Any questions before we break? No, nobody has any questions. So what we'll do is we'll go to break now. We'll come back at 6 o'clock and start back up again.
Okay, great.
That sounds great.
All right, great. Thank you. All right, so we're gonna go ahead and go to break now, and then dinner will be served.
We're still on camera. Yeah, we can pull off. Tony, are you still on this thing?
Yes, I'm here.
All right, do we want to just pause it for 15 minutes, or how do you want to handle it?
I think you just leave it go. Just leave it go.
Okay.
Just mute your mic, and then when you come back, you can turn your mic back on. We'll cut the video, so it doesn't matter.
Okay, cool. How's the sound and everything? Everything sound okay? Working all right?
Yeah, everything looks good.
Okay, great. We're going to take a break here, and we'll be back in a minute.
Yeah, I think this was a perfect time for a break. Everybody was getting a little tired, so this is good. It was good stuff. So we got the next material coming up. Excellent. Thank you.
Thank you, sir.
Thanks, Steve. All right, so we got less than an hour.
See, it's a little bit different because when we did this one, we did an intro, we did a big intro before, and that took up more time. We did the intro to asset protection, etc. But by combining the two, we don't have that intro. So we can write into cryptocurrencies. It's a nice little break when you go to the foreign trusts. So we skip a whole kind of 20-minute introduction. The intro was originally intro to asset protection, where you can lay the groundwork for the cryptocurrency being used.
Oh, right.
Trust. We've already got that.
Right.
So it's really a different seminar.
Is this
and
what
I think
we're
it really
doing?
works well.
Is this what we're doing in June or whatever?
Okay, guys. Hey,
One in
I
June.
think we're going to be getting back at the top of the hour. So I have it 6 right now. Andrew, how are things there?
Okay, Tom.
Yeah, this one I think.
This one's for you, T.
Thank you, thank you. Andrew, okay, maybe he can't hear us.
They might be. They were getting some food, so.
Okay.
But it's a hard stop at 70. I got a tennis match.
Yeah, no, they have a hard stop at 7 as well. So
Yeah, I know. I
okay,
don't want to get into one of these, never-ending stories. I do want to keep them on the list though, T, and use this seminar to speak every year here and in the north branch of the Miami FICPA.
Yes,
Oh yeah, all of them. So Shapiro. All of who?
it's scary.
Really? Yeah, it attracts a certain type. That's why we have these cases.
I'm gonna have lunch with Brian next week.
You'll like him a lot. You really will.
I do like him.
No, you'll like him a lot. He'll be good at dealing with that, trying to figure out all that, how to deal with the personalities.
I'm just gonna tell him to look. There's a lot of opportunity out there, and I want to have him gone. Convey the message. I see a lot
Yeah,
of
convey the
opportunity
message.
for him
That's what I
to
did.
participate.
That's what I did.
And get his name out there.
That's all I had to. Yeah. He was excited. He's been great with this stuff again. Great.
It's just, it's not, when you're doing some of this extra stuff, it's not paid. So if he's on the,
Oh, he doesn't.
because I think it'll lead to paid stuff.
It's not
I think it'll lead to full paid stuff. Yeah. Okay.
I don't think it's an issue.
I'm always reluctant to ask somebody to not get paid, but
No,
it's another reason you start to
I
charge.
don't think it's an issue. Mike's got him doing,
50 an hour.
huh?
150 an hour.
It's rough. If it was 300, I'd say, I don't know.
I mean, you could bill every minute. So then that's the thing about that.
We pay it.
You bill
Every second.
Every second you're thinking about something. A lot of the litigation, you work all day, you bill 6 hours. Because you really can't transition and get it. You just.
It depends. Depends on the case.
Yeah, you can for depositions and for some stuff you can.
Well, it depends on the payer.
Okay, everyone. So while everyone continues to enjoy the wine and the salads and the food's going to be coming out, we're going to go ahead and get started again. Gary and Eric, are you ready for us?
Yeah.
Yes, sir. We are ready.
Okay, perfect. So I'll go ahead and turn it back over to you guys, and we're going to be getting into the introduction to cryptocurrencies.
All right. Welcome back, everybody. I hope the first session was informative, and now you've had a chance to get some wine, some coffee, combination of the two, and we're going to keep going here. We're going to break a little bit from the asset protection. I'm going to give you a little background on cryptocurrencies. You know, primarily Bitcoin. That's the first one that we think about, and but there are several. And then I'm going to turn it over to Gary, and Gary's going to give you some information about foreign trusts. There's a lot of tax information in there, and then we're going to put them together, and we're going to talk about how you might use cryptocurrencies as one of your holdings in a foreign, or not how you might use it, but why it represents the ideal asset for a foreign trust.
We've got a question that came in on cryptocurrencies.
Great.
Is it a pyramid scheme?
No. Well, hold on. I answered too fast. Is it a pyramid scheme? Originally, no. Now there's not a whole lot of people. Ironically, you get some young attorneys that are like out of law school and they know what cryptocurrencies are, and they're being consulted, and they came up with this idea to do these ICOs, initial coin offerings, which sounds a lot like IPOs, and I'm going to tell you why that's a bad idea. It's catchy, but a bad idea. The attorneys might know about cryptocurrency, but they don't know about, they don't have a lot of experience in law. And so I have met with some clients who are developing new currencies, cryptocurrencies, altcoins is what we call them. And they have, they'll say they have a different purpose. We're going to use this one for charitable fundraising. We're going to use this one to clean up the environment. We're going to use this one to pay strippers. Literally, somebody told me, that was one of their ideas. Like, we want a cryptocurrency where you can pay 6 strippers and sex workers. And these are all, by the way, legit. Like, I met with somebody, they wanted one where we can, use this coin, and this is how you're going to pay charities. And I always ask this, well, how are you going to make money? Now, Bitcoin has sort of taken on a life of its own. Ether is another one that has gained traction because it has some intrinsic value. If you've heard of smart contracts, smart contracts are one of these concepts that are run on virtual currency platforms, and Ether is sort of the leading platform, and you will execute smart contracts on the Ethereum platform by paying the people who the people who log the contract, so to speak, in Ether tokens. A lot of the new currencies that you hear about, the ones that are popping up, there's hundreds of different ones. These ones that have no intrinsic value, are they a pyramid scheme? They're not. They don't exactly fit into it, but you have to ask yourself whenever you're looking at these, what is the value that's being offered? And so when I meet with folks and we're talking about it, I say, well, okay, how are you going to make money? Because it's great to want to save the world, but you still got to, even the charities that are saving the world still need money to do it. How are you going to make money? How are you going to monetize this? And they traditionally had wanted to use these ICOs, initial coin offerings. We're going to come up with a concept, and we're going to tell people, hey, we've got these coins, and you could buy the coins and be on our network, and we'll sell the coins in an ICO. Well, the SEC has cracked down on that. The SEC has said that an ICO is a lot like an IPO, and therefore we can regulate it. And this is where I could diverge into a longer story about how cryptocurrencies and alternative coins are like orange groves. But let me just tell you that the test for a security isn't whether or not you call it a security. This is, again, one of these examples where the law is pretty smart. The SEC years ago recognized that people are going to come up with investment ideas, and if you have certain factors that for your investment where it falls into these certain components, then we're gonna regulate it like it's a security. It's an investment vehicle, whether or not you call it a security. And basically, those factors are if it's a common enterprise, if the common enterprise is led by and promoted by, and the profits are driven by what the SEC calls a promoter, a common person or entity, and if the profits are pooled and distributed. And you understand that is the case with any publicly traded stock and with any, with any security, but it's also the case with a lot of other things. We saw that in the real estate market in the early 2000s. I'm going to build a condo tower. We're going to, one person's going to build it. We're going to rent them all out. We'll sell them. You can own your condo here in Miami. We'll rent it out. We'll manage it, and we'll pool all the profits and we'll pay it. Well, the SEC says that's a security. That goes all the way back to a case here from Central Florida from years and years ago. It was Howey and the Hills, the Howey case, which developed the Howey test. And it was a guy who was selling orange groves, and that was what he was doing. He was selling Northerners an opportunity to buy a piece of the orange grove, let him manage it. Yeah, you buy a little platform in the orange grove, let him manage it, and he would pull the profits and pay it. And it went all the way to the U.S. Supreme Court. The Supreme Court said, it walks and talks like a security. We're going to call it a security. So I'm going to bring this full circle back to your question. Is this a pyramid scheme? No, in the truest sense of what these tokens are supposed to do, at least in the sense of Bitcoin and Ethereum. It's a store of value like gold or silver or dollars. But with some of these new ones, you have to do an analysis on a case-by-case basis. And I bring up the security issue because a lot of these things, if they can't do an ICO, because now the SEC is cracking down and saying, hey, these things look like securities, we're going to regulate them. Well, if they can't do an ICO, then where's the value? And if they can't monetize it, then the only way they can get value out of it is to try and hype it like it has some value and then dump it. And then in that case, it's going to be, I think, yeah, you're probably on track with a Ponzi scheme.
It's not exactly like a Ponzi. Maybe you can go into some of the technical means by which these coins are created. A Ponzi is where people are paying into a scheme, and that payment goes to the people at the top of the pyramid.
Well, that's
is that what's happening?
Kind of what this is. You sell the coins,
okay.
And then that coin is that money that's derived from the sale of the ICOs is where the profit's generated. It's not, they're not profiting inherently. It's not like I've created Amazon, and Amazon is this, revenue generating machine, and I'm going to let people buy a piece of Amazon. This is, I've created an idea with this token or this coin, but that's why I always ask people when I meet with them, and I've had 3 in the last month that I've met with, and somebody just emailed me earlier today. They've got the charitable. I've had people email me and ask me about monetizing these things, and my question is always back to them, like, okay, well, what's the plan to make money? How are you going to generate revenue? How are you going to generate cash? And if there's no plan to generate cash besides the ICO, and that's where the Ponzi issue comes in. If there's no plan to generate cash, then yeah, it does look like a Ponzi scheme. If this thing doesn't have inherent value, like I said, Ethereum, Bitcoin, there's some value that's inherent in these particular cryptocurrencies.
In this blockchain technology.
Yeah, in the technology. But if the only value is created by selling the token, then yes, I guess it is a Ponzi scheme. So I initially said no, and now you just got me to convince myself yes. That was a great question.
You've changed him. I can't do it. I've been trying.
How was that? Did I do okay? Should I move on?
Yeah, we can move on.
Maybe you could explain.
So,
yeah.
Very good answer.
All right, so, I've got, pardon me. So I talk about cryptocurrencies, and what cryptocurrencies are is they started with Bitcoin, and it goes back to 2008. I think a lot of people know the story now of Satoshi Nakamoto, which is this, this person or maybe a group of people. It's been rumored to be anybody from the mob to a Japanese secret society to the U.S. government, who came up with a plan for digital currency. And the problem, I'll give you a little history lesson here on digital currencies. The problem traditionally with digital currency was that when you're transferring anything on a computer, the file continues to exist on your current computer. You could just make a copy and transfer a copy. And that was the problem that Napster ran into back in the late 90s, is Napster was allowing people to buy and sell music because they were saying, well, it's no different than selling a CD. If I buy a CD from the music store, I can resell it under the first sale doctrine. I don't want to go too far, of course, but the difference is between selling a CD and selling a digital rights to a song is that I can keep the song on my computer and also have it on the other computer. And with currencies, that has always been the problem. How do I know that when I transfer currency to another computer that it's deleted off of my computer? You normally need an intermediary like a PayPal to say, okay, you send this money to PayPal or a credit card company or a bank or a closing agent, escrow agent, etc. A third-party intermediary is normally required, but on the internet, it's been PayPal. You need this third-party intermediary to say, okay, I got the funds, I got the value from one source, and now I'm holding it, and now I'm going to transfer it to another source. And the blockchain technology developed by Satoshi Nakamoto solved this issue of how do you make sure you transfer value without having it be in two places at once. And the way, and I'll talk about blockchain, but that's what generally revolutionized this whole issue with cryptocurrencies. I talked about various coins. I've got a chart up here that shows market capitalization. That's just, and this is heavily outdated given the volatility of the cryptocurrencies over the past year. But as of mid 2017, we had $42 billion. If you took all the Bitcoin and added up what Bitcoin was selling for and the total outstanding Bitcoins, 42 billion. Now I'm here to tell you that if a bunch of people started trying to sell their Bitcoin, you're going to, just like the stock market, you're going to drive the price down substantially. Second in line was Ethereum. Full disclosure here, I own some Ether. I actually own a little tiny bit of Bitcoin, but it's literally a fraction, just enough to be familiar with it. I own some Ether and I own some Ripple, and I own some Litecoin. So I own the top 4 on here for various reasons. I'm not advocating ownership or investment in these, but I own them for my own personal reasons. But these are the coins, these are the most popular ones that have gained traction and value. But beyond these, there's probably hundreds, literally hundreds, because people have seen, well, I can create this coin, I'm almost creating a currency out of thin air and get value out of it. But they ran into that hurdle with the SEC that I explained. I talked about Bitcoin. Bitcoin's the first of these cryptocurrencies, and it works on the blockchain. And what makes Bitcoin work is math concept called cryptography. And I'm going to show you in a few minutes what a key looks like. It's just a series of numbers. So if I want to send a Bitcoin to somebody, I send it to a series of numbers that acts as their public address. And then in order to send the Bitcoin to validate the transfer, I have to enter in a private key. And that private key that I alone hold is what allows me to send the Bitcoin to somebody else. Now, I'm not really sending it. What I'm really doing is I'm really just telling the ledger to update the public ledger, the blockchain ledger, and I'm telling the blockchain that you should subtract a certain value of Bitcoin from my side of the ledger and add it to the side of the ledger of the person that I'm sending it to.
And so I'm lost with this, but I just wanted to add a few words for the uninformed here like myself. So under the underpinning of these cryptocurrencies is this blockchain. And so maybe Eric, you could tell the group when how the blockchain is maintained and why it works.
Let's move on to blockchain. This gets a little confusing, I hope. Normally, if I have a live audience, I've done this a few times live, and I can give some examples, and there's some folks in the audience that are familiar with Bitcoin and blockchain. But So blockchain, that's what Gary's, and this has been a hot topic of late because blockchain is a database that can really be used for more than just cryptocurrencies. But it revolutionized the digital currency concept because it was first used in connection with Bitcoin. And the way the blockchain works is anybody can go on and look at the original Bitcoin blockchain. And you go to blockchain.info and you can look at every transaction. And the blockchain is just a database that's stored publicly that updates a publicly viewable ledger with information about the transfer of Bitcoin. And because it's public, it offers a layer of transparency. And the way it gets updated is that anybody can decide to be a miner. And so now people are, over the last couple of years, people have become aware of this concept of miners. And the miners in the Bitcoin world are those people who sign up and offer their computer processing power to validate transactions. And so whenever somebody wants to send a Bitcoin or a fraction of a Bitcoin, a little bit of trivia for you, the smallest fraction of a Bitcoin is down to 8 decimal points, and that's called a Satoshi. So you don't have to buy and sell a whole Bitcoin. Actually, you can buy a little fraction, which is what I own.
Just in case you're about to buy.
It's a Satoshi.
Yeah.
Well, if you want to experiment with it, you can buy a Satoshi. It costs you a few bucks, and you can just see how this works. But what the blockchain is it's a public ledger that when somebody wants to send Bitcoin if I'm sending Bitcoin to Gary, for instance, I go on and I find Gary's public address. I say I'm going to send a certain amount of Bitcoin to him. I enter my private key, another series of numbers, and I send that message to the blockchain, and then that gets sent out to all the miners. And they all now have to engage in this. It's a competition essentially, but it's just a mathematical competition, and there's a math formula. And the math formula is part of the cryptography, and whoever solves the math problem first is the first miner to validate the transaction, and they send the message out to everybody else. And the way it works, and I don't understand this part in total detail, but I'm just going to give you a broad description. It's kind of like doing a square root of a really big number. It's a situation where solving the problem is difficult, but validating the answer is very easy. So I use the square root analogy. Finding the square root of a 10-digit number can be incredibly difficult through trial and error with just a simple calculator. But once somebody tells you this is the square root of this, you can just multiply the root by itself and validate that that's true or not. And that's how I kind of look at the blockchain, is that once the first person finds the answer, and it's designed in such a way that it takes a little bit of time and some processing power, and that's what creates integrity in the system. Once that first person finds the answer, they send it out, and when everybody else validates, and really it's more than 50%, once more than 50% validate that that's true, then the ledger gets updated. So you've managed to create a system that updates this public ledger without a third-party intermediary, through just volunteers who are the miners. Now, I say it's more than 50%, but really, if the blockchain's working properly, everybody should come up with the same answer once the first person solves. The reason it's important, why people are motivated to be the first person is that in the Bitcoin system, whoever the first person is to come up with the answer gets rewarded with a payment of Bitcoin. And so the system is designed to shoot out Bitcoin to whoever comes up with the answer first. And this will go on for a certain period of years, after which all the Bitcoins are distributed. And then now the only way to update a transaction is through payment that you can provide when you want to make a Bitcoin transaction. So you add in, it's kind of like adding a tip. It's like, I'll tip you and I'll pay a little bit extra, and then the system will validate the transaction. But it's a public key system using cryptography that can be viewed by anybody. And it's just math equations. You don't need a third-party intermediary. That's what makes the blockchain so revolutionary. Is it's a solid, secure system that's not controlled by anybody, can be viewed by everybody, and it's an online database technology. So, what the blockchain enables with respect to Bitcoin, it's decentralized. That means there's nobody that controls it. There's no government. There's no, you can't sue blockchain. You can't sue Bitcoin. It's a system that several, probably now several million people participate in, and it's all done through this public key cryptography system. It's secure. It's nobody's ever hacked Bitcoin, or we have had a situation where you've had a couple what are called forks, where you have people that come up with different answers to the problems, but that has been solved. So far, every time that's happened, that's been solved. There's no third-party intermediaries. That's supposed to reduce the cost, reduce the friction in the system, and create a situation where two people can do business on continents apart without any other individual verifying or validating their transaction. Once something is put into, once the blockchain ledger is, once a block is created, it's called a blockchain, by the way, because each block contains data or information, and each block is linked to the next block, and the math equations connect all these blocks in such a way that if you change one, it has to change all the other ones. So it creates an irreversible database. If you want to unwind a Bitcoin transaction, you have to do a new transaction, and that's going to be recorded on the blockchain. And Bitcoins obviously have gained a degree of value, high value. I'm not quite sure why, but they have. That becomes the question there, whether or not it's pure speculation. Pseudonymous. This refers to the anonymity of Bitcoin. If I want to remain anonymous, I can just tell somebody, you know what? I'm going to sell whatever I'm going to sell. And this became the big issue with the dark web. And so I'm going to sell drugs, I'm going to sell guns, something illegal on the dark web. You're going to pay me in Bitcoin. If anybody is familiar with the idea of cyber ransom has been paid with Bitcoin. And the notion here is that I don't have to give anybody my name, my address, my bank account information. All I have to give you is my Bitcoin is an address, which, by the way, I can go on, I can print address after, I don't have to have one, I can have thousands of addresses. I can create a new one for every transaction. And I can go on, I can create an address and say, send Bitcoin to this address. And once you send it, I now have that Bitcoin. It's irreversible because of the blockchain technology. And you have no idea who you sent it to, where it went to. I could be anywhere on the planet, and I could pull it off, and I can now spend that Bitcoin by simply using my own key attached to the address that I received it at and transferring it to somebody else. Bitcoin's not, fair is kind of a questionable term at this point, but it's not government manipulated. It's actually, Bitcoin is the computer system is designed to release Bitcoins to miners at a certain pace, so that there's only a certain amount of Bitcoins ever in circulation at one time. And that's supposed to prevent inflation. And Bitcoin allows for international transactions without friction, without having to convert currency, without having to deal with customs, border issues. Individual governments have a problem with it, but so far nobody's been able to actually stop it or control it.
We got a question.
Yeah, fire away.
Yeah, on the Bitcoin, who decides like the rate that these are being released at, and that maximum amount that's out there at any point in time?
Great question. So the question, as I understand, is who decides the rate at which Bitcoins will be released, or what the amount is in circulation at the time? It's written into the software. This is the genius of Satoshi Nakamoto, whoever this was. The software actually designates a certain rate at which the cryptographic functions are solved, blocks are added to the blockchain, and each time there's a cryptographic function, so I don't have to keep saying cryptographic function every time, let's just call it the puzzle. Every time the puzzle is solved, Bitcoin are distributed, and that it started out with several, I think it was a couple hundred Bitcoin. Then it was, at one point it was 50, at one point it was 25, then it was 12.5. Frankly, I'm not sure where it is right now, but a certain amount of Bitcoin get released. And then here's another part of the genius, is that the difficulty of the puzzle increases as Bitcoin transactions increase. So every time there's more transactions added to the blockchain, the program is written in such a way that, if you think about it, if I was solving for like a number, and I was let's just say I was trying to guess a number, and I'm trying to guess a 10-digit number. Well, if I decide, okay, no longer do I have to guess a 10-digit number, I have to guess an 11-digit number. Mathematically, it makes it twice as hard, and if I'm just guessing at the same rate, my odds have now created a situation where it will take me twice as long to guess the proper number. That's really what it is. It's almost like guessing. And so anyway, the software is designed to control the rate at which the puzzles are solved and the amount and rate at which the Bitcoins are distributed to the miners. That's a great question. So it's all pre-written is the simple answer.
And who owns the software?
Say that again?
Who owns the software?
Another great question. Because it's decentralized, nobody owns it. It's a public source software, which is why you're seeing, by the way, all these altcoins, these alternative coins and cryptocurrencies are all based on the same, essentially the same Bitcoin concept. Some of them have their own twist. In the Ethereum world, more information and data can be stored, which is why Ether and Ethereum are used for smart contracts. But it's public sourced. Satoshi Nakamoto, whoever, again, this person or group of people was back in 2008, dropped this into a public forum and said, hey, I've got this concept, drafted a white paper, and put it out there for all the world to see and use. And that's why you're seeing such a growth of altcoins and cryptocurrencies today. Nobody owns it, nobody controls it, anybody can use it.
I got another question.
Sure.
What's it based on? So if someone's to buy a Bitcoin, is it based on US dollars?
No, in fact, it cannot be. US law says you can't peg anything to the dollar. This is the most interesting thing about Bitcoin. It's based on whatever you're willing to pay for it and whatever somebody is willing to pay and somebody's willing to sell it for. So that's why the value is, it's very speculative. It's not tied to any intrinsic value. The Bitcoin proponents from years ago would say, well, neither's the dollar, right? We went off the gold standard, the dollar is whatever the US government says it is. But the dollar is backed by the full faith and credit of the United States government. Bitcoin is just whatever it happens to be trading for at the time. And that's why it swings so wildly. It's not based really on anything other than whatever anybody thinks it's worth. There's been a comparison, if you haven't read about the tulips in the Netherlands, the tulip craze, you should read about that. It's pretty fascinating. It's short, there's probably a Wikipedia page on it. But actually the best analogy I've seen is to fine art. Some people just want to own this because they want to own it. And why is a certain painting worth $40 million? Because somebody's willing to pay that for it.
All right. We got a follow up to that question, Eric.
Yeah.
What is that? Okay. Okay, so he wants to kind of clarify his question. So if he wants to, like right now, like acquire Bitcoin, what does he use to acquire? Does he yeah, does he pay with whether, like he's saying, like shoes or something, or cash or services?
Okay, there are some trading forums you could go on and start Googling. You can meet somebody in person and get Bitcoin. The easiest way is to sign up with one of these, what do they call them? Coinbase is the biggest one. So it's an exchange. Now, Bitcoin is pretty easy to get. There's now Bitcoin and Bitcoin Cash. That goes back to the fork thing, which is a little beyond, I don't really have time to cover that. But you have a couple of your biggest ones, Bitcoin, Ethereum, Litecoin are available on Coinbase. And anybody can go on to Coinbase, kind of like PayPal, link a bank account or link a credit card, although these took a hit recently when a few credit card companies, I think Chase and a couple other ones, said we're no longer going to let you buy Bitcoins with a credit card. But you sign up for an exchange is the easiest way to do it. But if you have a whole bunch of these, if you have a lot of value in Bitcoin, I don't recommend you keep them on an exchange, because exchanges are where the hacks have taken place. And so, you're at risk. But that's the easiest. But the other way you can get them is through a private transaction, or, there's like Bitcoin enthusiast, you can go out, just meet people out on the street and they just send you Bitcoin through your phone or through a computer or through the key system.
And you would have to obviously give them something to receive that.
You can, on the exchanges, you pay with dollars.
Okay. So it's like that you pay with dollars. He said on the exchanges you would pay with dollars.
With dollars, you
Link it
can
to your bank account.
you link it to your bank account and transfer bank funds, and then there's a fee for that. The exchanges make money doing that. Like a little bit, one that's a little bit more difficult is the XRP from Ripple. So I told you I have a little bit of Ripple, and I bought some. That was probably a bad idea, but I was curious. You can't, there's no exchange that I'm aware of where you can go buy Ripple. So I had to actually exchange something for Ripple, and I exchanged, I was able to trade some Ether that I had from a long time ago and acquire Ripple with it. So sometimes you can exchange one currency for another. If you're really curious, feel free to give me a call. I like talking about it. I think it's interesting. I think a lot of this is, 80% of it's going to be flash in the pan type stuff, because it's probably going to implode. But the technology will stick around for the long haul. But give me a call or shoot me an email, and I'm happy to chat about it off, at length.
Yeah, and we have their business cards at the front desk there for both of them. So yes, we have another question.
Sure.
Do you accept Bitcoin for legal services?
Great question. I have wanted to, because I do a fair amount of technology work, both in litigation, some transactions, and I thought a while back, it'll be a good idea. I'm like, we should just take it, for the principle of taking it. And I'm about, next month, I'm doing a seminar. It's a national webinar through National Business Institute on the law of Bitcoin and cryptocurrency. And then going through the tax ramifications. I'm not really a tax guy. Gary's a tax attorney. We've got a couple other folks here. My tax experience amounts to, I'm licensed in tax court, and so I can go argue whatever you spoon feed to me. But I'm not a tax attorney. But when I look at the tax issues around Bitcoin, it's just too if it's complicated for a business owner, I don't want to deal with it. So we don't take Bitcoin. There are a lot of businesses that do. For a while, I believe Microsoft, Dell, Amazon, there's big companies that were taking Bitcoin. I don't know if they still are. And the problem is it varies so widely that when you take a payment, especially for an attorney, the issue that we deal with is not only the tax ramifications. What if I take a Bitcoin payment in the morning and it's worth $1,000 and it jumps to $1,200? Do I have a capital gain? At the end of the day, maybe it doesn't make a difference. It's a short-term gain or it's profit. But if I'm an attorney and I quote somebody a fee of $1,000 and they pay me in Bitcoin, it's one Bitcoin, and by the end of the day when I batch it out, it's $1,200. Do I have an ethical duty to return the other $200? This is the stuff I think about. I'm like, it's just too much to think about. And so as a law firm, no, we're not taking it. If there was some mechanism where you could get a real-time exchange, or if the bar suddenly said you could take Bitcoin, or if the federal government suddenly said, you know what, we have a digital currency, which is probably coming, by the way, then yeah, absolutely, I would take it in a heartbeat. But when there's hair attached to it, I don't want to attach something with hair attached to it to my business. I'd rather just leave that for legal analysis and have somebody else pay me to do it.
Yeah,
In dollars.
In dollars.
So the value changes so often too. So you get something. You can get something
Right.
in the morning, and
That's right. And you could
and for less than that, you could be worth $600 by the end of the day, and it was
for a lawyer. If I quote a fee, if I say, okay, my rate's $400 or let's say I say it's $400 an hour, and we do something for 3 hours, you pay me in one Bitcoin that's worth $1,200 at 9 a.m. If that Bitcoin's worth $1,500 at the end of the day when I'm batching out, I might have a duty to give it back to you. But if that Bitcoin's only worth $900 at the end of the day, I probably can't come to you and ask for more money. I just took a haircut. So I'm like, for lawyers, it's like the worst of everything.
Yeah, so we've got a follow-up to the question. What is that? Someone just mentioned that a workaround would be to quote your fee in Bitcoin. Um, but I guess what he's saying is basically.
I would love to. The problem with quoting the fee in Bitcoin is now you get into the barter and exchange rules where then I need to go talk to our accountant and again, it gets confusing for me. If I have to think too hard about getting paid, if I have to think too hard about getting paid in any case, I'm reluctant to take on the case, and I don't want to just self-create those problems. I love the idea of taking it, but we don't.
I don't
because,
love the idea. I don't love the idea, but it's interesting.
Get another question. What is it? So considering all the issues that around valuing this currency and using it and what it's worth, is this something that will be around, it's in the next 15 years, or it's something that's gonna, fall out?
Great question. I think that a couple of the currencies will stick it out. There are countries like, Estonia's put their whole election system on the internet by using the blockchain. Delaware has a corporate initiative where they're issuing corporate shares on the blockchain.
That's the software. That's the
on the blockchain software. But you have countries like the one on the equator, Ecuador. Thank you, Ecuador. That does not, Ecuador basically uses the U.S. dollar, and they're kind of like, some of those African countries jumped right over landlines and went right to mobile phones. Well, Ecuador jumped right over paper currency, and they're going right into trying to create their own digital currency. I think that eventually there will be probably a universal digital currency, and it might be Bitcoin, or Bitcoin might end up being the Betamax of the currency world. There will be something. I don't think they'll all stick around. I think the technology is here to stay, and I think the concept of digital currency is here to stay. But if I was holding a whole bunch of Bitcoin and I suddenly found myself flush in Bitcoin, I'd be selling that stuff slowly.
All right. Any other?
So I'm going to talk about. I'm just going to talk about how you hold the Bitcoin.
Somebody has a comment.
And go ahead.
That there is a great article either this month or last month in Smithsonian about the Bitcoin and the changing in currency.
Yeah.
Starting with the paper currency and in the 17th century. Okay, and it was talking about that. So that's like the evolution of currencies. So basically, starting out with that, the currency at the beginning, now going all the way through now to Bitcoin. So there was, I don't know, I guess you're saying if I don't know if you guys saw that article.
I haven't seen that one. I'm going to send you actually when we jump off here later. I'll point. There's a couple that I did for Forbes, and I'll send you those on tying the Bitcoin with the asset protection.
Is that in our report?
I don't know. Oh yeah, we could. Yeah, if we have the report, that article's in there. I will undoubtedly this concept of digital currency solving this, the intermediary problem where you can have this public ledger has revolutionized computer technology, has revolutionized currencies. The concept is amazing, and the fact that this came out in the middle of this, the great, what do we call it, the Great Recession in 2008. It's undoubtedly a fantastic revolutionary concept, but I don't know if this is going to be around in 5 years. I don't know if it's going to be around 2 years.
Well, the actual coin.
Yeah, if there'll be any value, and Bitcoin could be worth $100 next year, or it could be worth $100,000. There's no way to know. It's pure speculation. And but there are people who may want to hold it. And what's interesting is that this key technology, the key technology is what provides this opportunity for asset protection. Because if you're holding assets offshore, or you're holding assets, remember we talked earlier about having a trustee be somewhere else and where are your assets. the worry that people have is if I use an offshore trust or if I put assets somewhere else, well, now I'm giving control to somebody else. But if you understand how the public and private key work, now I sent out, it was a late handout, but I circulated, and it's actually, it's on one of the slides that we'll see later. It's a picture of a paper wallet. So the paper wallet shows the public key and the private key. Remember, if I want to send Bitcoin to somebody, I send it to their public key, which is a series of numbers. And then what'll happen is, say, okay, you want to send to this public key. Now you need to sign it or you need to validate it. The way you validate it is with your private key. And only the person with the private key or anybody who has the private key can send that Bitcoin or that currency somewhere. Well, that private key is it's this long string of numbers, like 40 digits long. And what that does, it creates this opportunity to just really break up the key or give somebody, I can take all my Bitcoin, have it all in what we call a wallet, which can be any number of items that I'll talk about in a minute, and I can give the key to somebody else. And if I don't have the key, I have created a true impossibility situation. Remember earlier we talked about impossibility in connection with contempt and trusts and courts forcing the repatriate the assets. If I can't access the asset, I've created a true impossibility situation. And the wallet is where you store your Bitcoin, and this can be either on a computer, it can be on an exchange, it can be on a phone, it can be in your brain with just the numbers, or it can be on paper. And there's a slide that has a picture of a paper wallet example. And then you have the two keys. The public key is where you send the Bitcoin, the address, which is a series of numbers, and then the private key is the password, another series of numbers that you use to validate the transaction. And this chart here that I just flipped onto shows, what'll happen is I could have it like on my computer or phone, and then I'm going to send it somewhere. I can create a new wallet, and then I could just go on the computer. You could go to the blockchain.info and just generate a brand new wallet, just unique to this transaction. And that third little picture there, the long series of numbers, 4EAUJ, that's the address. So that's where you're going to send it to. And then there'll be another series of numbers that looks a lot like that I'll have to plug in, that'll be private, that'll only be available to me, that'll validate the transaction. And then it shoots it onto to the Bitcoin network. And that's the blockchain. And if you just want to see what it looks like, go to blockchain.info and you'll see like transactions constantly popping up. These are the transactions that are being validated, and it sends the Bitcoin to somebody else. And it's not really sending it. All it is really just a ledger saying, it's kind of like the bank. If you bank at Bank of America and I bank at Bank of America and I transfer money to you, the bank isn't walking over to my account and taking the money out and putting it in your account. The bank is just updating the ledger and said, okay, Eric just transferred $100 to Andrew. Actually, I prefer that Andrew just transferred $100 to Eric. And then by subtracting it from Andrew's side of the ledger and adding it to Eric's side. And that's what the blockchain does. But it does it digitally, and it does it by using these third-party miners. A lot of deep stuff here. I hope I've kind of conveyed it in a way that makes a little bit of sense.
Yeah.
And we're lighting it up with some foreign trusts.
Yeah, wait till you hear this.
Well, we only have 10 minutes, so we'll do an overview.
Oh, yeah, sure. What's the question? Okay, so for the FBAR and the issues related to that, would this be considered a U.S. bank account or a foreign bank account?
It's not a bank account.
It's
for FBAR and 8938.
It's an asset.
Yeah, it's not.
You have to report the asset to as an asset, especially if you buy or sell.
It's a sale of a capital asset, but it's not an FBAR issue.
And there was a case last year. The government's been subpoenaing some of these exchanges.
It's like an investment. It's not an FBAR issue.
Right.
Right.
So it would be financial instrument like 8938.
It's considered an asset, not
It's
by
not
the
a
IRS.
Forex. Yeah, it's not a Forex.
It's not a financial instrument. The IRS now, it's interesting. And this we're going to cover in my other
We have
the law of
another
Bitcoin,
seminar. Yeah.
because Treasury considers it. You have to have a money transmitter license in order to deal in Bitcoin, but the IRS doesn't consider it a currency. The IRS considers it an asset, and you just tax it like if you were buying and selling any other asset.
But it's simple except for the withholding rule.
To be situated.
Say that again.
Where is the asset deemed to be situated? It's a financial asset? Is it in the U.S.? Is it foreign? Where is it deemed to be situated?
I'm not sure I don't think that's been
I don't know
established.
if that's been established, but I
No.
think it would be wherever the individual is who controls it. I think if it did come up before court, if that was a question, or if that was any authority was looking into it, that's the first I've actually heard that question. So that's another great question. Go back to the Barber case where the LLC, the court said, well, you're sitting here and LLC interest is an intangible interest and it resides with you, so the interest is here. I think the same probably applies to Bitcoin or any other cryptocurrency because you have the address.
Yeah, but I think they're referring to the situs of the tax asset.
I think
Is what
I think it's going to be
it's
wherever
related,
you are.
but the IRS can just peg it.
Sure.
Yeah, they
Yeah.
just
That's
peg it.
I have not heard. That's the first I've heard that question.
Yeah, well,
And
Brian,
I haven't had anybody address that
Brian
issue.
at our firm has been studying this in some depth as well. So when you guys are going to do
We're doing in
seminar?
June. We're doing a June seminar, and I have rights to those materials. So if you're really interested in this, we'll have a lot more written materials on the whole law of cryptocurrency.
And the tax.
Reach out to me, and we're covering the tax, we're covering Treasury, we're covering the ICO issue, we're covering this notion that people think they sold Bitcoin, and like I traded some Ether for Ripple, and so I can do a 1031 like-kind exchange. Obviously, you folks know that's not going to happen. I can't just sell something, take the cash, buy something else, and call it a like-kind exchange. But we're going to cover all that in the law of Bitcoin. It's a multi-hour seminar in June. And so if you're interested in that, let me know. Just shoot me an email and I'll share some materials with you. And you can sign up for the webinar as well. We're doing, I think it's a 2-hour webinar in June. So I've eaten up all of our second half here. I didn't give Gary hardly any time.
He does
talk
this.
about
He does this all the time.
Foreign trusts, and I'll tell you, this is a page turner. So if anybody's been suffering from insomnia lately,
No, this will put you right away.
then this will solve that issue for you.
If you
I'll
weren't
flip the
already
slides
asleep,
and let Gary talk.
listen, they're already asleep. Wallets. We had touched on foreign trusts, and the reason we brought foreign trusts after Bitcoin is, to wake everybody up. But we close out Bitcoin with the idea that you can print out your key, your public and your private key, and tear them apart and give the private key to a trustee. And the trustee now holds the entire Bitcoin asset in a foreign trust. How a U.S. court could reach that, I don't know. You want to stay away from trustees who do business here because they can be served here and they can be pulled into litigation here. So a pure foreign trustee, very, very difficult to reach. We talked about some of the means by which some of the courts have tried to hold people in contempt to make a distribution. But if you cannot force a distribution from that trust, it's very, very strong. I think we already went through the fact that the domestic is not as strong. It's exposed. We went through the Barber case, and we went through all the other DAP
We talked
cases.
about Barber.
Now, Sargent's interesting. There's a case here, noted Sargent. So, the wave was to kind of reach U.S. assets, and a judge has a judgment. Let's grab what's here. I don't care what the law is. But an appeals court in Miami went through a litigation. Al-Sala suffered a judgment in, I think it was even federal court, and Al-Salah had a number of assets all over the earth, most of which were certificated corporations. But those certificates were not held in Miami or in the U.S. And so the judge did something that was very interesting, very old school perspective, and that was, you got your judgment. That's my job. You won in court. You have the judgment. I am not going to put Al-Salah in jail to disgorge assets. That is not my job. You can now take that judgment and domesticate in Dominican Republic and United Arab Emirates to get Al-Salah shares, which is really not much of a win. So Al-Salah says, that's great. I'll move the shares whenever you get close to my shares, and you can never reach me. That is the law in Florida. So when we talk about LLCs, for instance, we may want to consider a foreign LLC where the shares are offshore. Not what Ms. Barber did with the craziness with the fraudulent transfer and the running around, but legitimate planning. Let's put the shares offshore with a foreign trustee.
Well, let me add too that, with an LLC, a lot of people recognize that an LLC, you don't need to create shares or certificates, and that's just referred to as being certificated. You don't have to do that. It's not one of the formalities that's required, like with stock, but there are advantages.
It's a good idea.
And so now we are advocating that you create an LLC. If you're doing a Nevis LLC, I would create a Nevis LLC, certificate the LLC, create whatever it is, 1,000 units of this LLC, and stick them in a safe deposit box in Nevis, maybe designate a Nevis manager or not, but put them somewhere else. Again, it gives you an argument. And from a litigation perspective, you always want to have an argument.
It's a serious argument.
And now because of Al-Salah, it's definitely one that I would actually cite this particular case and say, you know what, Judge, you can't come after my folks here. It's not an intangible interest like Barber. Remember, they said, oh, it's an LLC interest that's attached to the person. I say, it was intangible, but we created certificates, and the certificates are in Nevis. Had Sabrina Barber created certificates and put them in Nevis in the Wells Fargo case, I think that's a different case.
Well, she would have at least had an argument.
Yeah.
They pretty much crushed her. But this is pretty clear.
You want the next slide?
Yeah, we've got
a few minutes. We're not going to hit tax. You're almost going to want Gary.
Well, I'll give him the overview.
All right, so
here's some selected characteristics of some foreign trusts, and that can be formed in different jurisdictions that you'll see on there. Nevis is very strong. Those are great characteristics. Belize is very good, and Cook Islands is very good. This is just selecting trustees. You want to go with a well-known trustee that has more than $4 or $5 billion in assets. I mean, you hear these stories. We've never suffered it, but where someone picks some trustee and the guy takes off with money or something like that. There are other safeguards, by the way, to ensure that a trustee doesn't take off with your money. But you always want to use a very, very well-established trustee. I've never had a problem.
Which, by the way, back to the cryptocurrency, if they only have part of the key, of the private key, they can't take off with your money.
You can
they can keep you from taking off, but you could actually create a situation where you only give them part of the information necessary to transfer the asset. That's why, in theory, again, I'm not advocating you do this, but in theory, cryptocurrencies represent such a great asset for offshore planning.
It's like having two signers on a bank account.
Exactly.
Yeah. So tax-wise, this is just a little overview. We do so much international tax work. Hablamos español si tienes cliente de América del Sur. I know you've got a lot of Latin CPAs there, but I'm probably being redundant because you guys do so much international work. But we have U.S. persons, we have foreign persons. U.S. persons pay income tax on all income wherever it's earned on Earth. The estate tax is different. The estate tax is basically, if you're a U.S. person, you pay the estate tax on wherever you have it. But if you go to the next slide, non-U.S. persons pay income tax only on U.S. source income, okay? And of course, most of you are probably aware of the loophole for stock. So in other words, if you're not a U.S. person or a resident or a citizen, you can sell U.S. stocks and bonds all day, and there's no tax. Otherwise, on income, you have 30% withholding, and real estate is subject to graduated tax rates as well. The estate tax becomes an issue for non-U.S. people, non-residents, non-citizens, only with respect to what they have here. If you're U.S., well, what I'm going to hit here for a second, I guess we got a minute. The issue is if you're not here, your U.S. assets become estate tax assets for what's here. So if you're coming in, if you're foreign and you're coming in, that's where the planning comes in. That's where
Your book? Do they have your book?
Yeah, they have a few. That's a smaller book with
Gary
all the
wrote
currency
the book
on it.
on the gift and the estate tax for the non-U.S. citizen.
Uh-huh.
Highly recommend it. It's dense but short read, but you guys will get it.
Just keep in mind that foreigners can give intangibles freely. So foreigners can give away U.S. stock to their kids or otherwise without paying any gift tax. But if they die with that stock, it's subject to estate tax. This goes through kind of the gyrations. When are we dealing with a foreign trust? And it has to do with whether a U.S. court can bind the trust or it's managed by a foreign person. By the way, it's automatically foreign, unless a lot of people don't understand that. Unless a U.S. it defaults foreign, exactly. Unless a U.S. court can bind it.
Okay, we got a question. What is it?
Yeah.
So the question, and then he's gonna get to the question, but basically, since you guys do a lot of foreign work, and you obviously here in South Florida, we deal with a lot of Venezuelans, and
So
what was the question?
so with respect to the activity that they have in the conversion of their assets, whether it's their assets and their income.
whether, with respect to, in particular, Venezuelans, the issue pertains to the conversion of income or assets?
I'm sorry, what was that? What was it? With respect to converting Venezuelan bolívares,
Converting.
Oh, bolívars.
at this point, there's 3 different conversion rates.
Conversion rates.
Okay, are these Venezuelan people living here or there?
You know what? That's a good idea. Come on up here and talk to him, because he'll be able to hear anything. It's better that way. That way, because you have a good question and there's a lot of detail. Come on up here, because they can hear you when you talk into the microphone. Yeah, go ahead. He's gonna actually just talk into the mic because his question's detailed. There's a lot of background and stuff. So
Complicated. Thanks.
As you may know, or the group that's gathered here tonight, we have a lot of Venezuelans that have substantial assets, and they're all coming to live in the U.S. and they're becoming U.S. tax residents primarily because of the fact that they're spending more than a certain number of days in the U.S. So at that point, they become U.S. tax residents regardless of whether or not they are legal U.S. Citizens or residents. So they have investments and receivables and all kinds of transactions. And unfortunately, it's very difficult. I don't know if you are aware, but if you look at what's printed out at the Internal Revenue Service with respect to what the conversion rate is, it gives you one number. If you go to the Department of the Treasury of the United States and you look up what they consider to be the exchange rate for bolivars to U.S. dollars, they get another rate. Then if you use what they call it the DICOM, is the exchange rate for the goods and services that the government needs. Of course, they need medical equipment, they need food, they need a number of very basic products, and they have another rate. And then there's a true black market rate, which is what you can really get dollars for in Venezuela. And that's like right now it's 800,000 bolivars for every dollar. So, you know, when a client comes in, they go, well, let's convert my numbers. And I go, which number you want to what number do you want to use? So my question to you, you being in a law firm, what number do you use? Do you use the Treasury? You use the IRS? You use the DICOM?
You mean like if they have income, this is Gary, if they have income and you're trying to track it because they're a resident and you're trying to do it through conversion?
Well, let's talk about just doing an 8938 financial instruments, or we do an FBAR. We're trying to talk about what the value of our foreign bank accounts or what our income is from earnings that they have companies in. They own and operate. You know, they have operating entities operating in Caracas, in Venezuela, and they have income. What do you convert it at?
You have to use the IRS rate.
Yeah, but how about the Department of U.S. Treasury?
That should be the same.
They're not. They're like,
if they're not,
different.
consider the idea that Treasury and the IRS, go back to the Bitcoin example. Treasury considers Bitcoin to be currency. And so they want to regulate it as currency and make you register as a money transmitter and a money transfer agent in order to move it. But the IRS says it's not currency, it's property. And so we're going to tax it as property. The IRS, for purposes of filing with the IRS controls.
Yeah, you got to go with the
And
IRS.
so I don't know. I'm not the tax guy. I don't mean to be a Mr. Badinsky here, but if I'm arguing this issue and I'm saying we did the right thing and I'm over in Tampa at the tax court, I'm going to say we followed IRS rules with respect to our filings with the IRS. If we do something with Treasury, it might be different, but with the IRS, we're going to follow whatever the IRS has said.
All right.
That's great. Thank you very much.
All right.
All right.
Good night.
Good night, everybody.